afternoon, everyone. Hope everyone is doing well this afternoon.
Your Honor, your volume seems quite low. It may be, I just don't, let me turn up my volume and see if that makes it better.
Let's see, can you hear me now, Ms. Walker?
Yes, but you sound echoey.
Is it echo?
Yes, definitely. Almost kind of like you're talking from a little bit of a distance.
Mr. Jordan, are you there?
I'm here, Judge.
Let's see, I don't see if there's anything wrong with, that I can see with the computer here. Is everyone else hearing an echo?
Yes, Your Honor.
Can we see if we can, Mr. Jordan, if we can get someone to help me with that? What about now? Is there still an echo?
That's much better.
Okay, so somebody had turned the microphone off. You all are lucky it's just a microphone, otherwise we would have had some problems. Thank you, Ms. Falk.
No worries.
All right, let's see, the SAP reset date is September 27. And if everyone's ready to go, the court's ready, so just let me know where you'd like to go first.
Good afternoon, Judge.
Good afternoon.
Whenever you're ready, we're gonna start in for position 22, Mr. Rivera.
Okay, Ms. Gant, did you have something that you needed to say?
Yes, Your Honor. Good afternoon. I do apologize for interrupting. I'm requesting a breakout for position 13.
13 needs a breakout, okay. Any others need a breakout this afternoon? Okay. Let's see. Good afternoon, Mr. Rivera. I'm Judge Eric Morrow. This is a state expedited accusation calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You have been charged in case 22 CR 006-127F with battery family violence. Is there a history? Good afternoon, Ms. Jackson.
Yes, Your Honor. The defendant has 2 cycles. The defendant's last arrest was December the 6th, 2019 for driving while license suspended or revoked. And that was in Gwinnett County. There was no disposition for that arrest and there are no convictions listed in the GCIC. Nothing in addition.
Thank you. Who's representing Mr. Rivera this afternoon? Ms. Gant, could you help me out?
It's actually a conflict, Judge. It should be Ms. McLeod.
Okay. I see you there, Ms. McLeod. Are we ready to proceed?
It doesn't look like she signed on. We can move on to the next case.
I had seen her on the camera just a minute ago, so I know she was on.
Yeah, I do actually see her name now, but her screen is not on.
No, it's not.
Okay.
Okay, if we could have someone send Ms. McLeod a message, please, we'd appreciate it. And let's move on to the next case.
Walker,
Position 14, and it's Your Honor.
we're gonna, no, what's her name again? Ms. Goffrin, we're gonna start in courtroom 2, Ms. Goffrin.
It's golfing.
Okay, we're starting in courtroom 2. For position 27, Walker.
So what position is it again?
27, Walker.
27, okay.
This is Tariq Walker, Your Honor. This is Attorney Mike Barber. I'm here for him.
Okay, good afternoon, Mr. Barber. Let's
Good
see.
afternoon, sir.
Good afternoon, Mr. Walker. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video? You're on mute, courtroom 2. Is that a yes? Is that a yes, Mr. Walker?
Yes.
Okay, thank you. You have been charged in case 22 CR 006-132G with simple battery family violence. Is there a history, Ms. Jackson?
The defendant has 2 cycles. The defendant's last arrest was October the 27th, 2015, with theft by taking and burglary in the 2nd degree, and that was in Fulton County. Those charges were dead docketed. There are no convictions listed in the GCIC.
Ms. Falk?
Yes, Your Honor. This happened on September 11th at 2:45 p.m. over at 3160 Overhill Court Southeast. The victim, who's Miss Jakebia Reed, that is J apostrophe Kievia Reed, common spelling Reed, stated she had made a Twitter post online in reference to the defendant, who's the father of her child. The defendant then came to her residence in order to speak with her. And once inside, the defendant actually grabbed the baby out of her arms and struck her in the face. When the officer spoke to the defendant, he did admit to slapping her in the face while they were inside of the residence. Although he only has a prior burglary and theft by taking, we do have some concerns about the violence imposed in this case. The fact she was holding their child and he took the child out of her arms and then slapped her in the face and then admitted to police he had done so. The state's recommendation is a $3,000 surety bond. We are also asking a stay away from 3160 Overhill Court Southeast. There is no indication that the defendant lives at that address, so he has no reason to be at that address. We are further asking for no further contact with Miss Reed, third-party contact with the child, and one-day anger awareness. Thank you, Your Honor.
Thank you. Mr. Barber?
Well, I think we'd be good with everything except the surety bond. I would ask it not be a surety bond, Judge. He is self-employed. He owns a auto repair business, Reeks Mechanics, and it is mobile auto repair. It's not even detailing. It's actual repair work, and he's got a truck and everything that he uses. The prosecutor was correct. They do not live together. They do have a 5-month-old baby together. He lives at 3802 Alderwoods, which is in Jonesboro, with his mother. He goes to church at the Light of Joy in Riverdale. This is the first disagreement they've had the entire time. They're high school sweethearts, and he did everything he could to help her take care of the baby, taking her to all her appointments, helping out with everything he could, even though they're not married and the child's technically not legitimated. But he's never missed an appointment or anything. I think the child is very important to him in his life. I would ask for either a lowered surety bond or a signature bond, but the other conditions are fine with the third party with the child. We would agree to all of that. I think 3,000 surety bond's kind of high. That's all, Your Honor.
Okay, it's going to be a $3,000 signature bond through pretrial, one-day anger awareness, no further contact with Ms. Reed, stay away from the Overhill Court address. I'm not going to keep him from his child, but he can have third-party transfer for visitation of the child, no drugs, alcohol, or weapons while out on bond. All right, good luck to you, Mr. Walker.
Thank you, Your Honor. That concludes my business. May I be excused, sir?
Yes, have a good afternoon, Mr. Barber.
Always a pleasure. Thank you.
Yes. Who do we have next?
Position 24, Smith.
Good afternoon, Mr. Smith. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
You have been charged in case 22 COI 006129J with battery and cruelty to children in the 3rd degree. Is there a history, Ms. Jackson?
The defendant has 34 cycles. The defendant's last arrest was April the 14th, 2022, for a probation violation in Marietta, Georgia. The defendant does appear to be a multi-state offender. He has arrests out of New Jersey, Pennsylvania, and New York. The defendant does have misdemeanor convictions. It's one in 2021 for theft by taking, an additional one in 2021 for theft by shoplifting, one in 2016 for a habitual violator, one in 2009 for a DUI and a hit and run, and driving while license suspended or revoked, one in 2001 for petty larceny. Nothing in addition, Your Honor.
Thank you, Ms. Falk.
Yes, Your Honor. This incident happened September 11th, 2022 at around 8 p.m. at 624 Cimarron Parkway. in Sandy Springs. So just to give some context, this was less than 24 hours ago. LaShawanda Lee, and that is LASHAWNDA, Lee, LEE, reported that the defendant, with whom she lives with, grabbed her by the throat while holding her head against the stovetop. He also ripped her shirt, and the child, 8-year-old CG, saw the altercation. So the officers then spoke to CG and asked what he saw, and he stated he saw the defendant push his mother. Also, Miss Lee had a long red mark going up her neck, which was consistent with her statement to police about being grabbed by the throat. The victim and the defendant are in a relationship. They do live together, but they do not share any children. CG is not the child of the defendant. And she did confirm that he grabbed her neck. She stated she did not lose consciousness during the time where he grabbed her neck. So that is why we were not able to upgrade this to an aggravated assault. She did confirm, however, that she was burned on the stove, because when he pushed her down against the stovetop, I believe the stove either had been turned off recently or was still on. So she does confirm she was burned. We learned that after we had taken out these charges, which may require us to revisit an aggravated assault charge. She also stated she does not want contact with the defendant. She wants to stay away from the residence, and she is filing for a TPO today. She also stated she will need a one-time law enforcement escort to retrieve his belongings, and she is, I believe, on Zoom today. I just want to point out one thing that pretrial, kind of because his history is so extensive, missed is he also has cycles out of Delaware. So he has cycles out of Delaware, Pennsylvania, essentially the Mideastern region, as well as cycles out of New York and Georgia. I saw arrests for harassment on his record, for indecent assault in 2007. There were, I mean, essentially, you name it, he's essentially had those charges, ranging from traffic charges to charges of violence. I believe there was another harassing charge and a number of charges out of Georgia. So what we essentially have is a person who is, I believe, 42 years old, who has almost as many arrest cycles as he has years on this earth. And so the state's concern here is we have a person who has multi-state offender, who has charges out of other states for violent offenses, and now has a charge where he essentially took a woman's head and pressed it near a hot stove, causing her to be burned in front of an 8-year-old child. So for obvious reasons, the state has some serious concerns in regards to this defendant, and that is why the state is recommending a $5,000 surety bond. We are also asking for stay away from 624 Cimarron Parkway in Sandy Springs. We're asking for no further contact with LaShawanda Lee and CG, as well as no alcohol, drugs, or weapons. And I just want to reiterate, Your Honor, this is not just our request. This is the request of the victim herself.
I'm sorry,
Nothing
Ms. Well,
further.
what was your request for the bond amount?
$5,000 surety bond, Your Honor.
Okay, thank you. Good afternoon, Ms. Kim.
Yes. Well, Mr. Adam Smith is 42 years old, and he has resided here in Georgia for 14 years. He has 2 children from another mother, and they are minors, 12 and 11. So he is taking care of them financially. And he has 2 jobs right now as an assistant manager at the Wingstop, and he has a GED. We would like to request for signature on bond, and yet because of multi-state offense, if Your Honor is not inclined to give him a signature on bond, we would like to request for maximum $1,500 surety bond, Your Honor. And my client denies allegation. Thank you.
Ms. Lee, if you're on the call with us, this is now your opportunity to speak. If you choose to, you do not have to, but this is your opportunity. I don't know if I see a Ms. LaShawn Lee on my screen, but if we do.
Yes, I'm here.
Okay, can you activate your camera for me, Ms. Lee?
Do I have to get on camera?
Yes, ma'am.
Okay. Yes, hello.
Good afternoon, ma'am. And I take it that,
Good afternoon.
good afternoon. I take it that you're not driving, are you?
Yes, I'm currently at work. I'm sorry.
Okay, I'm gonna have
Oh,
to.
but I'm currently at work. I just wanted to
Hold
I
on.
just wanted
Hold
to
on,
state that
Miss Lee, hold on a moment for me. You need to pull
yes,
over. Are you pulled over? Are you
yes,
driving?
I'm over. Yes.
Okay, all right. Now, can you
No,
raise?
I'm not. I'm over. I'm stopped.
Okay, good. That's what I need for you to be
So I
safe.
just wanted to
Hold
state,
on, Miss Lee. Hold on.
I just,
I'm gonna allow you to speak, but you're gonna have to wait for me, okay? I need for you to raise your right hand,
okay.
okay? There must be a delay, for why we're having this communication. Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. What would you like to tell the court, ma'am?
I wanted to speak in the behalf of Adam. We got into an altercation yesterday, and he's not overall a bad guy. You know, I just wanted to say that as far as the assault and the pushing of the head to, it was more of me I was protecting myself. I know he didn't intentionally mean to burn me. I'm sitting here listening to it, and I just don't want him to get like those charges to be this worst person. He's not that. So I don't think he deserves the immediate charge of him burning my face, because I know he didn't intentionally want to burn my face. And me burning my hand, it was by an accident.
Okay, anything else, ma'am?
That's all. But I do want to continue. I at this point, I just don't think we should live together, and I do want to file for a protection against him. I just want him to leave and go on with his life. That's all at this point.
Okay,
And that's what I've been trying to get him to do for the last 6 months, and we haven't been able to do it.
okay. Thank you, Miss Lee.
You're welcome.
For the battery, it's going to be a $3,000 good bond. For the cruelty, it's going to be a $1,000 good bond, which makes a total of a $4,000 good bond. No further contact with Miss Lee. Stay away from the incident location. He can go back to that location on one time with law enforcement escort. No drugs, alcohol, or weapons while out on bond. All right. Good luck to you, Mr. Smith.
Thank you, Your Honor.
Thank you, Your Honor.
Position 20, Middleton.
Good afternoon, Mr. Middleton. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Good afternoon. Mr. Middleton, you've been charged in case 22 CR 006140F with willful obstruction of a law enforcement officer. Is there a history, Ms. Jackson?
Judge, the defendant does not have any prior arrest on file.
Okay. Good afternoon, Ms. Bacchus.
Good afternoon, Your Honor. Good to see you.
You also.
Thank you. This incident occurred on September 10th, so 2 days ago. An officer was notified that a male, who's later identified as the defendant, was, I guess, vending or selling items on personal property. When the officer attempted to approach the defendant, he ran from the officer, and once the officer caught up, the defendant also physically resisted arrest. Your Honor, we are aware that this defendant does not have a significant history, and so for that purpose, the state is recommending a $2,000 signature bond and to stay away from the incident location, which was 1059 Ralph David Abernathy Avenue in Atlanta. Nothing further.
Good afternoon, Mr. Bixon. You represent Mr. Middleton, is that correct?
Yes.
You have any objection to the state's signature bond?
No, Judge, we're totally fine with it.
Okay, so it'll be a $2,000 signature bond through the jail. No alcohol, drugs, or weapons while out on bond, and stay away from the incident location. Okay?
Thank you, Your Honor.
Judge, thank you.
All right, you're welcome. Anything further in my court, Mr. Bixon?
No, Judge, may I be excused?
Yes, have a good afternoon. Thank you.
You too. Good to see you.
You also. Good luck to you, Mr. Middleton. Who do we have next?
Position 19, Mack.
Good afternoon, Mr. Mack. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. You have been charged in case 22 CR 006135F with theft by receiving stolen property and driving while your license was suspended or revoked. Is there a history, Ms. Bacchus?
The defendant has 9 cycles.
Oh,
The
I'm sorry, Ms. Bacchus.
I was gonna give it to you, but
Okay, Ms. Jackson, is there a history?
Yes, Judge. The defendant has 9 cycles. The defendant's last arrest was August the 20th, 2022 for driving while license suspended or revoked. And that was in College Park, Georgia. There was no disposition for that arrest. The defendant does appear to have an open case pending in Fulton County for possession of cocaine and possession of a firearm or a knife during commission of a felony and possession of a firearm by a convicted felon. That case number is 21 SC 178411. The defendant does appear to have an additional arrest. I think it was one in 2021 for theft by receiving stolen property. The defendant does have a prior felony conviction that was in 2010 for possession of marijuana with the intent. And the defendant has misdemeanor convictions. So one in 2017 for theft by shoplifting, and one in 2007 for possession of marijuana less than an ounce. Nothing in addition, Your Honor.
Thank you, Ms. Bacchus.
yes, Your Honor. The state's recommendation on this case for count 1, I believe there's a $4,000 surety in place. We are asking that $2,000 surety remain in place on count 1, and on count 2, we are amenable to reducing to a $500 surety. No further contact with the victim, Obafemi Obaje. Obafemi is spelled Obafemi. Last name is spelled OPA-AJE. A stay away from the incident location, which is the Red Roof Inn at 2450 Old National Highway in College Park, and no alcohol, drugs, or weapons while out on bond. An officer was called and when he arrived, observed a surveillance video of 2 males entering the parking lot at that incident location. One of the males stepped out of the vehicle and entered the Red Roof Inn. The other male lingered on the south side of the parking lot and took a license plate off of a vehicle. The male that took the tag off the vehicle met with, I guess, another male in the same parking lot. Then they exchanged that plate that was captured on the Travel Lodge Motel footage at 2471 Old National Parkway. And the male who received the plate then walked back into the 2450 address, walked up the stairwell, and gave that plate to the defendant. The hotel staff advised that the defendant was the registered guest in that room. And the defendant was observed pulling into the parking lot of the incident location. And at that time, he did not have a tag on the car. Based on the recent history and the open case, Your Honor, we feel that a surety bond is more than appropriate in this case. Nothing further.
Thank you, Ms. Gant.
Thank you, Your Honor. Mr. Johnny Mack is 33 years old. He has been in the Atlanta, Georgia area for 8 years. He has community ties, including a brother and also 2 children, ages 4 and 6. We are opposed to the stay away at the incident location, or in the alternative, we're requesting a one-time law enforcement escort, as my client does have belongings there, including his car, clothing, and shoes. Your Honor, Mr. Mack completed the 11th grade. He is currently a forklift operator. Well, let me back up. He is set to start a new job as a forklift operator tomorrow at Higher Dynamics. He Prior to obtaining this position, he was unemployed for 3 months. Therefore, he does not have the means to pay much, if anything, toward bond. He strongly denies the allegations. Specifically, he denies being the driver of this vehicle or receiving any stolen property, Your Honor. I do acknowledge my client's history. However, he is innocent in any open cases. The last death conviction was 2017, Your Honor. That is remote in my opinion, and I am requesting a signature bond, Your Honor. And if Your Honor determines that he is ineligible, then I would ask for a bond of no more than $1,000, and that would be $500 for theft by receiving and $500 for driving while license suspended. Thank you, Your Honor.
Okay, it's going to be for the theft by receiving a $750 good bond, for the driving while license suspended a $250 good bond, making a total of $1,000 good bond. No further contact with the alleged victim. Stay away from the Red Roof Inn on Old National Highway. He can go back there on one occasion with law enforcement to retrieve any belongings that he might have there. No drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Mack.
Thank you, Your Honor.
Thank you, Your Honor.
15, Jones.
And this is Tyler Jones, is that right?
Yes, Your Honor.
Good afternoon, Mr. Jones. I'm Judge Eric Moore. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. You have been charged in case 22 CR 006142H with simple battery family violence. Is there a history? Ms. Jackson?
The defendant has 3 cycles out of North Carolina. The defendant's last arrest was February 28, 2009, for driving while impaired in Fayetteville, North Carolina. The defendant does appear to have an outstanding hold out of Leftwich, Georgia, for a failure to appear. The underlying charge was not listed. The date on that warrant is October 17th, 2019. The defendant has 1 misdemeanor conviction that looked like it was like out of the military or something. It seems to be associated, kind of like the CWAC, I guess. And he was administratively written up and reprimanded.
Okay, thank you. Ms. Bacchus?
Yes, Your Honor. This incident occurred 2 days ago, September 10th. An off-duty officer was working an extra job at the Boogaloo Club at 259 Ponce de Leon Avenue Northeast. He stated that 2 people flagged him down and told him that a man was on top of a woman and was choking her. So as the officer approached them, he saw the victim, Miss Jasmine Autry, crying, and a male who was later identified as the defendant. He appeared to be agitated and irritated. So the officer asked Miss Autry what happened, and she told him that she was in an argument with the defendant inside the club, and that he became angry and started yelling at her. She left the club to call an Uber so that she could return to the hotel room, and that's when the defendant came up behind her, pushed her to the ground, and grabbed her by the neck. Once the on-duty officer arrived and he spoke with the victim, she told the officer pretty much the same thing that she told the officer that was on the extra job. She said that he was very angry and just, or the officer said that he was very angry, talking loudly, and he confirmed from a bystander that she was pushed to the ground. And so based on the factors, the officer determined that the defendant was the primary aggressor. The state is recommending a $4,000 surety bond. Due to the multi-state history, I'm not even certain if this defendant lives in Georgia, as they were saying, in a hotel room. And so based on the lack of community ties and the out-of-state history, the state is recommending that surety bond, as well as no further contact with Miss Jasmine Autry. Stay away from the incident location, which is the Boogaloo Club, and 1-day anger awareness, no alcohol, drugs, or weapons. Nothing further.
Ms. Gant?
Thank you, Your Honor. Mr. Tyler Jones is 39 years old. He is a resident of Glen Burnie, Maryland. He has been in Maryland since 2018. He and the complaining witness, Ms. Autry, were visiting the Atlanta area for a Saints game. He shares a 1-year-old son with complaining witness, Ms. Autry. He also is the primary caretaker for 2 sons in Maryland, ages 16 and 17. He is not receiving any child support for the care of those children. Mr. Jones served 12 years in the Army. He is currently enrolled in the military. He has been in the reserves for 21 years and 8 months. He has a master's degree in project management. He is currently employed at the Department of Treasury and has been gainfully employed in that position since 2018. Mr. Jones denies the allegations, and I am requesting a signature bond. According to the report that I received, he is eligible. We heard a little bit about his history. However, I did not hear about any convictions for violence, Your Honor. Therefore, I am requesting a signature bond on Mr. Jones's behalf. And at this time, Your Honor, he does not want any contact with the complaining witness. We are in support of any orders for third-party transfer, and he does not have any belongings at the incident location. Therefore, we are unopposed and do not need a one-time law enforcement escort. Thank you, Your Honor.
So he does need third-party transfer, Ms. Gant?
Yes, Your Honor. The child lives in North Carolina with Miss Autry.
Okay. I'm going to release him to that hold. So it's going to be a $5,000 signature bond through the jail. Stay away from the 259 Ponce de Leon address. No further contact with Ms. Autry. Third-party transfer of the minor child. No drugs, alcohol, or weapons while out on bond. Mr. Jones, I'm going to let you out, but if you do not show up for your next court hearing, they will put a warrant out for you, okay?
All right.
All right, good luck to you, sir.
Thank you, Your Honor.
Position 7, Jesus.
Good afternoon, Mr. Jesus. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You've been charged in case 22 CR 006136Y with driving under the influence of alcohol less safe and improper passing on the right. Is there a history, Ms. Jackson?
The defendant has 34 cycles. The defendant's last arrest was December the 19th, 2021 for aggravated stalking, and that was in Johns Creek, Georgia. That case appeared to be still pending. That case number is 22 SC 181489. The defendant does have felony convictions out of California. There was one in 2013 for theft by taking a vehicle without the owner's consent and possession of a stolen vehicle. And there was one in 2011 for possession of a stolen vehicle. And the defendant does have misdemeanor convictions. One in 2019 for stalking, one in 2018 for harassing phone calls, an additional one in 2018 for criminal trespassing and simple battery family violence, one in 2013 for possession of marijuana less than an ounce, and one in 2012 for assault, and one in 2010 for possession of controlled substance, an additional one in 2010 for driving without a valid license. And the defendant does have a history of probation violations. There was one in 2019 and 3 in 2018. Nothing in addition, Your Honor.
Afternoon, Ms. Tortorella.
Good afternoon, Your Honor. The state's recommendation is as follows. For the DUI less safe, it's a $4,000 surety bond. For the improper passing charge, a $1,000 surety. That's a total of a $5,000 surety bond. The conditions is no driving, no drugs or alcohol, no weapons, and no new violations of Georgia law. Your Honor, as far as the defendant's likely to reoffend and commit felonies while out on bond. As you heard from pretrial, this defendant has a felony case. It's 22 SC 181489 for aggravated stalking. The offense date was December 18th, 2021. It was filed March 17th, 2022, and he received a $5,000 signature bond for that case. He is currently in violation of that bond order, as it is implied by Georgia law that a defendant not violate any laws or ordinances while out on bond. This incident, Your Honor, occurred on September 10th, 2022 at Old Alabama Road and Hunts Point Drive in Johns Creek. This defendant does poses a significant threat and danger to the public safety under OCGA 17-6-1. At approximately 12:30 a.m., Officer Bacon of the Johns Creek Police Department was stopped at the red light at the incident location already stated on record. When the light turned green, the defendant, Antonio de Jesus, drove around the officer's patrol vehicle on the right side of the road and in a right turn only lane and passed the officer on the right side. The officer then initiated a traffic stop and noticed physical manifestations of impairment in the accused. These manifestations included bloodshot, watery eyes, heavy eyelids, and the odor of an alcoholic beverage from the accused's breath. The accused agreed to standardized field sobriety tests and showed clues of impairment. The defendant was arrested and the officer read him implied consent. The defendant did agree to the state-administered breath test. The results showed his alcohol content was a 0.075. The officer reasonably believed the alcohol the defendant consumed, caused him to be a less safe driver. And all these events did occur in Fulton County, Georgia. Your Honor, he has 26 cycles out of California and 10 cycles in Georgia. He's a multi-state offender. As far as his driver's history, he pled guilty to seatbelt violation and failure to exercise due care on January 29th, 2018 out of Gainesville Municipal Court. His driver's history also shows he pled guilty to reckless driving out of Oakwood Municipal Court on January 12th, 2017. This appears, Your Honor, to be a reduced DUI sentence. On October 9th, 2013, he was found, he pled guilty to, he was convicted of possession of a controlled substance out of California. And in 2012, he was convicted of assault deadly weapon out of California. He has a violation of probation on his record out of California in 2012. He was convicted of that. He also has FTAs on his record. This comes out of his driver's history. On August 3rd, 2017, he failed to appear to trial out of Gainesville Municipal Court. And on July 30th, 2017, he failed to appear to trial again to Gainesville Municipal Court. For that reason, Your Honor, the state does feel a $5,000 surety bond is more than reasonable for this matter. Nothing further.
Ms. Johnston, good afternoon. Is this your case?
Yes, Judge, this is my case. Good afternoon.
Good afternoon. I believe this is the first time that you've been in my court, so welcome.
I think it's the second time, actually, but
Okay, so,
thank you nonetheless.
all right. Yes, you can proceed.
Thank you. Mr. De Jesus is 31 years old. He works as a truck driver and a forklift operator for Noble Solutions in Marietta. He has lived in Georgia for 8 years now, and currently lives in Alpharetta. He does assert his innocence on the open case as well as this case. We would be asking for a $1,000 surety bond on count 1 and a $1,000 surety bond on count 2. That is what Mr. De Jesus would be able to afford. We do acknowledge his criminal history, but he would be able to return to work upon release, and we're asking for that bond because of that. Thank you.
Right, so for the DUI, it's going to be a $1,500 good bond. For the improper passing, a $500 good bond, making for a total of a $2,000 good bond. No drugs, alcohol, or weapons while out on bond. Good luck to you, sir.
Thank you.
I'm sorry, Judge, I was on a call. What is the bond again?
1,500 good for the DUI, 500 good for the improper passing.
And this is a good bond, 1,500 and 500. Thank you.
Yes.
Your Honor, hi, Your Honor, I sent
Yes.
Ms. Grace and Ms. Bridgewater a felony transfer order for
Okay.
your review and signature.
Thank you. I'll get that signed. And I do see that we have Madam Interpreter on the line today. Are we going to need her for an inmate this afternoon? And if so, who is that? And can we make those arrangements?
Yes, Judge, that's going to be position 2, Mr. Apocro. I can't pronounce it.
Aparicio,
Yes.
Aparicio Cortez.
Okay. And is he in courtroom 2 with you? Or-
I would have to send him over there.
Okay, I just wanted to make sure that we start coordinating that so that that won't push us behind.
Okay.
Would
Okay.
it be, sorry, Your Honor, a quick question. Would it be possible for me to speak with him in a breakout room with the interpreter before his case is called?
Yes, Ms. Johnson, that's what I'm trying to arrange at the present time, okay? So once they have him in a separate room, we'll place you into a breakout room with your client and the interpreter, okay?
Okay, perfect. Thank you.
Okay, good. So who do we have next?
Good afternoon, Your Honor. This is courtroom 3. We have before you position 16, Amy Kent, and she has family members in the courtroom too.
Okay, thank you. Good afternoon, Ms. Kent. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video? Can you hear me, Ms. Kent?
Yes, good afternoon.
Okay, thank you. You've been charged in case 22 CR 006124J with theft by shoplifting and driving while your license was suspended or revoked. Is there a history, Ms. Jackson?
Yes, Your Honor. The defendant has 6 cycles. This is going to be a bond surrender, Your Honor. The defendant's last arrest was March the 28th, 2022 for driving while license suspended or revoked, and possession of Schedule II controlled substance, and possession and use of drug-related objects, and possession of a firearm or a knife during commission of a felony, and that was in Clayton County, Georgia. That case appeared to be still pending. The defendant was out on a signature bond through pretrial services for battery family violence. That case number is 21 CR 004991 and the letter J. There are no convictions listed in the GCIC. Nothing in addition, Your Honor.
Okay, thank you, Ms. Bacchus.
Yes, Your Honor. For the theft by shoplifting, the state has recommended a $3,000 surety bond, and on the driving while suspended, a $1,000 surety bond for a total of a $4,000 surety bond. Let's see, no further contact with the co-defendant, Tracy Lewis. I believe that's position 17 or 18. I'll confirm that. Stay away from all Family Dollar stores in Georgia. No driving while suspended, and no alcohol, drugs, or weapons. This incident occurred 2 days ago on September 10th. An officer was dispatched to the Family Dollar store at 1616 Virginia Avenue in reference to a shoplifting that had just occurred. The manager of the store advised that the suspects, 2, had just left and gave a description of the car and the tag number and the direction they headed. So the officer was able to track the vehicle and stated that the vehicle was indeed the vehicle used during the shoplifting, because when the officer approached the car, he saw a red Family Dollar basket full of the contents that were in plain view inside of the car. The car was parked at a motel, and the officer went inside and spoke with the manager, who gave a description of the 2 females as well as the room number, and allowed the officer to view the surveillance video, which showed the females drive into the motel parking lot, exit the vehicle, and enter the hotel. So while waiting for another officer, the officer saw the co-defendant, Tracy Lewis, walk out of the hotel towards the vehicle at that time, he stopped and detained her, and then the officer went to the hotel room and knocked on the door, and that's when the defendant answered the door, and she was also detained. And they were, again, positively identified because the manager of the Family Dollar did a show up at the location. The manager said that the items that were stolen, it was a comforter set, decorative pillows, bath rugs, soap dispensers, towels. I believe that's it. Your Honor, in addition to the history that was listed, we also have on the driving history, I can see in 2021, there were 2 FTAs, in another 2 FTAs in 2021, an FTA suspension in March of this year, another FTA suspension in June of this year, and 4 FTA suspensions in January of this year. So based on the fact that this defendant does not respond to legal process, a history, we have a 2015 robbery. I'm not sure of the disposition. I believe it was an arrest. And the open case and the bond surrender, Your Honor, we feel as though the surety bonds are more than appropriate in this case. Nothing further.
Thank you, Ms. Kent.
Thank you, Your Honor. Ms. Amy Kent is 21 years old. She has been in the Atlanta, Georgia metro area her entire life. She does have family here. Ms. Kent completed the 11th grade. She is now working on obtaining a GED. She is currently employed at Family Dollar, Your Honor, not at the incident location. She has been in her position for 4 months and she has not been terminated. Your Honor, therefore, we are opposed to any stay away conditions at all Family Dollars. We would consent to the stay away at the incident location. My client denies the allegation. She's insists that she showed a receipt to the police officers for the items that she had purchased from that Family Dollar. I acknowledge my client's history. However, I did not hear about any convictions. My client is presumed innocent in any open cases as well as this case, Your Honor. I am requesting a signature bond through the jail as she does have the other bond surrender issue to contend with. If Your Honor determines that she is ineligible, then I would ask for a low bond given the nature of the charges, Your Honor. I would ask for a total bond of no more than $1,000, and that would be $250 for driving while license suspended and a $750 bond for the theft shoplifting. And again, we are opposed to the stay away at all Family Dollar locations. Thank you, Your Honor.
All right, so it's going to be $750 for the theft by shoplifting, good bond, $250 good bond for the driving with a suspended or revoked license, making for a total of $1,000 good bond. No further contact with Miss Tracy Lewis. Stay away from the Family Dollar at 1616 Virginia Avenue. No drugs, alcohol, or weapons while out on bond. Okay, good luck to you, Ms. Kent. Courtroom 3, do we have Ms. Lewis there?
Yes, Your Honor. Position number 18 is Louis.
Okay. Let's just take Ms. Lewis since it's the same. Good afternoon, Ms. Lewis. Again, I'm Judge Eric Moore. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Okay, definitely.
Thank you. You've been charged in case 22 CR 006126E with theft by shoplifting. Is there a history, Ms. Jackson?
The defendant has 30 cycles. The defendant's last arrest was October the 9th, 2021 for battery, and that was in Fulton County. The defendant appeared to be on probation in Fulton County for battery, substantial physical harm. That case number is 21 CR 005375 and the letter E. That disposition date was October the 21st, 2021, and the term is for 12 months. The defendant does appear to have prior arrests for theft by shoplifting. So one in 2011, and there were 2 in 2014. The defendant also has a history of probation violations. There were 2 in 2020 and 1 in 2017. In addition to that, the defendant has a history of failure to appears. There were 3 in 2018 and 1 in 2016. Also, the defendant appeared to have an outstanding hold out of Marietta, Georgia for larceny. The date on that warrant is July the 20th, 2022. The defendant does have a prior felony conviction that was in 2008 out of Cobb County for possession of cocaine. And the defendant does have misdemeanor convictions. One in 2019 for theft by shoplifting, one in 2018 for criminal trespassing, and one in 2016 for criminal trespassing, additional one in 2016 for disorderly conduct. Nothing in addition, Your Honor.
Thank you. Ms. Bacchus, do you need to add anything to the facts?
No, Your Honor. Based on that history and the failure to appears and the probation violations, the state is asking for a $3,000 surety bond, no further contact with Amy Kent, her co-defendant, stay away from all family dollar stores in Georgia, and no alcohol, drugs, or weapons while out on bond.
Okay. Good afternoon, Ms. McLeod.
Good afternoon, Your Honor. My client is 44 years old. She is a native of Atlanta. She is a sole caretaker for 4 boys. They're 13, 10, 7, and 5, Your Honor. She had not been working for some time. She tells me she just started a job a few days ago and would like to be able to get out so that she can go ahead and get back to her job and, of course, to take care of her little boys. My client had been interested in some kind of plea arrangement would get her out of jail, but the prosecution is not interested in that, Your Honor. So I would ask the court to give her a signature bond. If the court is disinclined to do so, then as low a bond as possible, because she doesn't have anyone to help her to pay bond. And as I stated, she has 4 small boys that she is primarily responsible for their care. Thank you, Your Honor.
Okay, it's going to be $1,000 good bond, no further contact with Ms. Kent. Stay away from the Family Dollar Store, 1616 Virginia Avenue. No drugs, alcohol, or weapons while out on bond. Good luck to you, Ms. Lewis.
Your Honor, can you repeat that bond amount one more time?
1,000 good.
Thank you.
Thank
Your
you,
Honor,
Your Honor.
can we have position number 4, Ms. Loredia Clark? She has, Ms. Clark, have a seat here, please. She has family member in the courtroom too.
Okay. Good afternoon, Ms. Clark. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video. Do you agree to have your case heard by video? You are in mute, courtroom 3. Was that a yes, Ms. Clark?
Yes, good afternoon.
Good afternoon. Ms. Clark, you've been charged in case 22 CR 006120E with driving under the influence of alcohol less safe and driving while your license was suspended or revoked. Is there a history, Ms. Jackson?
The defendant has 2 cycles. The defendant's last arrest was July the 9th, 2021 for a DUI. And that was in Senoia, Georgia. The defendant does appear to be on probation in Cowardly County, Georgia, for a DUI. That disposition date was June the 20th of 2022, and the term is for 12 months. Nothing in addition, Your Honor.
Ms. Tortorella?
Yes, Your Honor. For the DUI less safe, a $6,000 surety bond. For the driving while license suspended, a $3,000 surety bond. That'll be a total of $9,000, a $9,000 good bond. The conditions is no driving, no drugs or alcohol, no weapons, and no new violations of Georgia law. Your Honor, we will be adding a DUI per se charge. As you will listen to the facts of this matter, they will support that charge. The driver's history states driving license suspended was on June 21st, 2022, with the reinstatement date of June 20th, 2023 for this defendant. So this defendant should not be driving at any rate, as the defendant's license is actively suspended. This defendant is a flight risk, as she advised the officers that she lives in Alabama. This incident occurred on September 10th, 2022 at Barnwell Road and Glen Ferry Drive in Johns Creek. This defendant does pose a significant threat and danger to public safety. Officer Jay Montero of the Johns Creek Police Department was patrolling the incident location at 11:57 p.m. when he observed a silver vehicle on the side of the road. The vehicle had a flat right tire. The driver and only occupant, defendant LaDaria Clark, requested the officers help to change the tire. While changing the tire, the officer observed the defendant to make an unintelligible statement and noted a strong odor of alcohol emitting from her person. After the tire was changed, the officer observed that the defendant's eyes were glossy, her speech was slurred, and she was swaying while standing. The officer asked for defendant's license and it did return suspended. The defendant said she knew the license was suspended, but she said she had a DUI permit to work, school, and medical locations. Defendant consented to field sobriety evaluations, which included the HEN evaluation, the walk and turn, and the one leg stand, where the officer found manifestations of impairment upon the defendant. After the evaluations, the officer informed the defendant she was under arrest, read her implied consent for drivers over 21. The defendant did consent to the state administered breath test. The breath sample indicated the defendant had a 0.224. A defendant was arrested, and all these events did occur in Fulton County, Georgia. The defendant does have 3 cycles. She was convicted of a DUI per se on June 20th, 2022, and striking an unattended vehicle out of Coweta County State Court in 2013, March 20th, 2013 to be exact. She was convicted of speeding out of Warner Robins Municipal Court, and her driver's history starts from 2010, Your Honor, and on. So for this reason, Your Honor, she shouldn't have been driving. She's a risk to public safety. She was driving while intoxicated. We do feel a $9,000 surety bond is more than reasonable. Nothing further.
Thank you, Ms. Johnston.
Yes, Your Honor. Ms. Clark works for a company. She is employed right now. She works for a company called Acosta. She would be able to go back to work if she was released from jail. She lives in Peachtree Corners, Georgia currently, and she has lived in Georgia since she was 6 years old. We would be asking for a $1,000 surety bond on count 1 and count 2 for this case. Ms. Clark cannot afford the $9,000 surety bond that the state is asking for. However, if the bond was set lower, then she would be able to get out of jail and go back to work.
All right, for the DUI, it's going to be a $2,500 good bond. For the driving while license suspended, a $500 good bond, making for a total of a $3,000 good bond. She is to report to DUI court within 2 days of release, and no driving while out on bond. No drugs, alcohol, or weapons while out on bond either. Good luck to you, Ms. Clark.
Your Honor, before we go back to courtroom, have a seat, please. Before we go back to courtroom 2, can we have the Spanish interpreter come into the Zoom so we can do Mr. Cortez?
So if we can put Ms. Johnston and Madam Interpreter, and good afternoon, Madam Interpreter.
Good afternoon, sir.
Into the into a breakout room, courtroom number 3, please. And we'll have to go back to courtroom 2 with cases that are not Ms. Johnston's cases.
Yes, Judge, this is gonna be position 22, Terrell.
Okay. Position 22, I have Rivera, is that right?
I think she means position 26, Michael Terrell.
Yes, I'm sorry. Yes, that's correct.
Okay.
All right, thank you.
No worries.
Good afternoon, Mr. Terrell. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You've been charged in case 22 CR 006131A with possession of a pistol or revolver by a person under 18 years of age. Is there a history, Ms. Jackson?
Your Honor, the defendant does not have any prior arrests on file.
Ms. Falk?
Yes, Your Honor. And I just want to point out before we start that the defendant just turned 17 10 days ago. His birthday was September 2nd. The facts of this case were on September 11th, 2022. The vehicle that the defendant was occupying was stopped at 4060 Janice Drive because the vehicle was pulled over after leaving the scene of an accident. The defendant initially stated that he had no weapons, but then subsequent to his being detained, a gun was found in the backpack of the defendant. As the pretrial said that this is the defendant's first arrest, there is a $2,500 surety bond already set. We are requesting that the surety bond remain as set, no alcohol, drugs, or weapons. Thank you.
I'm sorry, Ms. Falk. The vehicle was pulled over for what reason?
They had fled the scene of an accident.
Okay, and do you have how many people were in the vehicle? And
I do not, Your Honor. Obviously, this is a case that is currently, we are going to continue gathering items through investigations such as the police report and other items, but I do not know the number of people who were in the vehicle. I do know that he was not the driver, well, at least from what I could interpret, he was not the driver of the vehicle, but the vehicle was pulled over for fleeing the scene of an accident.
Okay, thank you. Ms. Kim?
Yes, Your Honor.
Mr. Terrell, you can put your hand down. You have a right to remain silent, so let Ms. Kim do the speaking for you. And if you need to talk with her at a later time, I'm happy to let you do that. But if you'll just keep your hand down for now, and if you need to talk with her, I'll allow you to do that. Thank you. Ms. Kim?
Yes, Michael Terrell is 17 years old, and his parents, siblings, all his family members are here because he was born and raised here in Georgia. This is his hometown. And I try to contact his father, Michael Terrell Sr., but I could not contact him. He works at City Trends retail store. He's been working there part-time for about 5 weeks, while he's going to military school, youth challenge school. He's 11th grade right now, and he's expected to graduate maybe next year. We would like him to continue his high school and complete. And this is his first arrest, and there's no, we would like to ask for a signature on bond for him, Your Honor. $2,500 surety bond is really high for 17 years old student who has that much money, Your Honor. Thank you.
I'm not disagreeing with you, Ms. Kim, but he's going to have somebody sign for him. I'm just not going to place him back out without you speaking with his parents or someone.
I'll try to reach his father continuously.
So I'm going to leave the bond where it is at the present time.
Okay.
With no drugs, alcohol, or weapons. But if you contact someone and you want to get him on a calendar sooner, I always have SAP calendars. I have one tomorrow. The SAP calendar, it's 2 weeks from now, but on the 27th. But if you or your office will get in touch with a parent, I'd much rather.
Hello, I think I got him, Your Honor. Sorry about that.
Okay, well, we'll have to go to somebody else while she's.
Yes, Your Honor. We'll circle back to this one since Ms. Kim is otherwise handling that case. If we can circle back, I know Ms. McLeod was on the Zoom in regards to, I believe it was Mr. Jordy Rivera, position 22, that we tried to address at the beginning of the calendar.
Okay, thank you, Ms. Falk. Can we go to Mr. Rivera, position 22, courtroom 2?
Yes, that's fine. Real quick, Judge, for position 26, Terrell, that's going to be a 2,500 good bond.
26.
Terrell, the one
the one we were just handling. I
don't know yet.
Okay.
So we're going to come back to him.
Okay, not a problem. This
Okay.
is position 22, Rivera.
Okay, so we've already, Ms. McLeod,
Yes, Your Honor.
As we opened up, I already spoke with him and I already got his history. I believe that this is his first offense, if I'm not mistaken.
It is, Your Honor.
That is correct, Your Honor.
Okay, and I had gone to Ms. Falk to give the facts of the case, so you can proceed, Ms. Falk.
Yes, Your Honor. We are recommending, and this is out of the norm, and I will explain myself, a $3,000 signature bond, no further contact with Benjamin Charles, stay away from 108. Well, actually, we're not asking for a stay away for the defendant, since Mr. Charles is also charged in this case, but we are going to request no alcohol, drugs, and weapons. So $3,000 signature bond, no further contact with Benjamin Charles, and no alcohol, drugs, or weapons. This occurred September 11th at 12:09 a.m. at 1084 Howell Mill Road Northwest, apartment 641. The officers came out and actually met with Mr. Rivera and his brother. The defendant, Mr. Rivera, stated he had been in a fight with his husband, Benjamin Charles, while they were out drinking. He stated that Charles struck him in the face, and Mr. Rivera had several red scratch marks and purplish blue bruising to his upper neck, ear, and eye. He also stated that Mr. Charles struck him in the head with a glass object, resulting in an open wound to the back of the defendant's head. Officers were able to see that he was bleeding. Mr. Charles was then interviewed, stated the defendant struck him first in the face with his fist, and the officer noticed bruising to the lower left eye of Mr. Charles and dried blood on his lips. Mr. Sauceda, who's Rivera's brother, stated that there has been previous violence between the two as recently as 2 months ago. Mr. Charles was charged with aggravated assault family violence, and given the lack of history with Mr. Rivera and Mr. Sauceda, Mr. Rivera's brother, making the statement, we do have concerns that Mr. Rivera was not the primary. We do have some belief that there's indicators that Mr. Rivera is not the primary aggressor, which is the reason why the state is asking for a signature bond. However, we are very concerned, since there had been altercations as early as 2 months ago between the two, that they stay away from each other. However, since we are under the impression that Mr. Rivera was not the primary aggressor, we are asking that he be allowed to return to the residence, and we're going to ask that Mr. Charles not be allowed to return to the residence.
Okay. You have any objection to any of that, Ms. McLeod?
I do not, Your Honor. My client has stuff at the residence. He has told me that he plans to move from there. He has not yet moved. He still has belongings there. He would prefer no further violent contact so that he can actually speak to the cross defendant concerning moving his stuff out, but he doesn't really want, they're no longer in a relationship, and my client plans to move.
Okay, so it's going to be a $3,000 signature bond through pretrial, 1 day anger awareness, no further contact with Mr. Charles, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Rivera.
Thank you, Your Honor.
And can we go back to Mr. Terrell, please? All right. Apparently, Ms. Kim has gotten in touch with Michael Terrell Sr.
Yes.
Ms. Kim, is your client, is he in high school?
Yes, Your Honor. 11th grade.
Okay, so he's going to have to stay in school.
Yes.
Okay. Ms. Falk, do you have the people that he was in the names of the people he was in the car with?
I do not, Your Honor. So I don't have the ability to ask for a stay away order. We would ask for a curfew. If Your Honor is inclined, which I feel like that's the direction Your Honor is going in, of giving him a pretrial signature bond, we would ask that he have a curfew from 6 p.m. to 6 a.m. No alcohol, drugs, or weapons, and Your Honor already stated stay in school. But I do have some concerns, particularly the fact that there has been such a hard time catching up with one of his parents that there may not be a very tight rein on his activities if he's, literally been in jail now since yesterday, and there was trouble actually catching up with a parent who would co-sign a bond.
Okay. So it's going to be a $5,000 signature bond through pretrial. He is gonna have a curfew. I'm gonna make that curfew 9 PM to 6 AM. He's gonna have his father as a co-signer. Ms. Kim, we have to make sure that, I believe he's gonna need a utility bill.
Oh, I thought, Your Honor, may he please waive utility bills? He is coming from work, so he may not have utility bills.
I want to make sure that he is at the location that he says he is, so I'm not going to waive the utility bill.
Yes, Your Honor.
Drugs, alcohol, or weapons while out on bond. And I think that's it. All right, Mr. Terrell, I am going to allow you. Ms. Jackson, do you have something?
Your Honor, is this gonna be parental co-signer since the defendant is 17 years of age, or adult co-signer?
It's going to be his father, Michael Terrell. Okay.
Senior?
Yes.
Yes.
Thank you.
I'm going to let you out, Mr. Terrell, but if you violate this curfew or if you violate any of the terms, you're going to be right back where you are, okay?
Yes, sir.
All right, good luck to you.
Thank you.
At 9 PM to 6 AM. All right, who do we have next?
Can we go do the interpreter case, please? Position number 2.
Okay, we can. Can you tell me what position that is?
Position number 2.
2? Okay, thank you.
Your Honor, was position number 12 Norcross? I'm sorry, I just want to see if I need to take them back.
It's my understanding that it was. Is that correct?
That's correct, Your Honor.
Okay.
All right, thank you.
I
All right.
sent the order over.
Okay. So, Madam Interpreter, if you'll raise your right hand for me, do you swear or affirm that you will translate from Spanish to English and English to Spanish to the best of your ability?
I do, Your Honor.
Okay, thank you. Good afternoon, Mr. Aprico Cortez. I'm Judge Eric Morrow. We are conducting this hearing by video. Do you agree to have your case heard by video?
Buenas tardes, señor Cortés. Yo soy el juez Morrow y estamos conduciendo esta audiencia a través de televideo. ¿Usted está de acuerdo con que continuemos tratando su caso de esta manera?
Sí, está bien.
Yes, that's fine.
You have been charged in case 22 CR 006118B with simple battery.
Usted ha sido acusado en el caso 22 CR006118B por golpes y lesiones simples.
Is there a history, Ms. Jackson?
¿Hay antecedentes, señora Jackson?
The defendant does not have any prior arrests on file, Your Honor.
El acusado no tiene antecedentes penales archivados, su señoría.
Ms. Tortorella?
Yes, Your Honor. The state's recommending a $3,500 surety bond, no contact with the victim, and her name is Bertina Rosario Diaz, and that's spelled B as in boy, E-R-T-I-N-A. Rosario is spelled R-O-S-A-R-I-O hyphen Diaz, D as in dog, I-A-Z.
Sí, su señoría, la fiscalía recomienda una multa bajo garantía, una fianza bajo garantía de $3,500 y no tener contacto alguno con la víctima Bertina Rosario Díaz.
To stay away from the incident location at 1940 Fisher Road, apartment 16B as in boy in Atlanta. 1-day anger management, no drugs or alcohol, no weapons, and no new violations of Georgia law.
Se solicita que se mantenga alejado del lugar en que ocurrió el incidente 1940 Fisher Road, el departamento 15B en Atlanta, y también que tome un curso de manejo de la ira. Queda prohibido el uso de drogas, armas y alcohol, y tampoco que incumpla la ley de Georgia.
Your Honor, this incident occurred on September 10th, 2022.
Este incidente ocurrió el 10 de septiembre del 2022.
This defendant poses significant threat and danger to the person of Bertina Rosario Diaz.
Este acusado es una amenaza seria para la víctima Bertina Rosario Díaz.
The defendant did intentionally make physical contact of an insulting and provoking nature with Ms. Rosario Diaz by grabbing her by her hair and punching her in the face.
Este acusado realizó contacto físico instigando, provocando a la víctima al tomarla por el cabello y también abofeteándola en la cara.
The defendant was arrested and all these events occurred in Fulton County, Georgia.
Este acusado fue arrestado y este incidente ocurrió en el condado de Fulton, estado de Georgia.
The state understands that this is a defendant's first offense.
La fiscalía entiende que este es el primer delito cometido por el acusado.
However, this is a violent offense.
Pero dado que esta es un delito violento,
This was originally charged by the officer as a family violence offense.
entonces el oficial lo acusó como un cargo de violencia familiar.
We saw no indication in the warrant of any sort of connection, familial connection between the defendant and the victim.
Y de acuerdo a todo el incidente, no se pudo establecer un contacto o relación familiar con la víctima alegada.
However, we will look into it and we will contact the officer to verify that.
Pero vamos a investigar y contactar al oficial para obtener más información de esto.
Therefore, we are asking for no contact with the victim and to stay away from the incident location and the surety bond of $3,500 as stated before this court. Nothing further.
Entonces, vamos a también a lograr queremos lograr que no tenga más contacto con la víctima ni que él vaya al lugar del incidente y queremos solicitar una fianza bajo garantía de $3,500 como se lo solicitó a su señoría anteriormente.
Ms. Johnson.
Yes. Mr. Aparicio Cortez is gainfully employed right now, and he would be able to go back to work upon release from the jail.
El señor Aparicio Cortés está legalmente empleado ahora y él podría volver a trabajar si puede lograr que se lo ponga en libertad ahora.
I want to point the court to the fact that Mr. Aparicio Cortez does not have any criminal history, according to the paperwork I received, does qualify for unsecured judicial release.
Yo quisiera solicitar a su señoría para el señor Aparicio Cortés, debido a que no tiene antecedentes penales, a que se le otorgue una fianza bajo firma.
For that reason, we would be asking for a signature on bond. And I also want to ask the court to allow for no violent contact. Mr. Aparicio Cortez is a provider for his family and would need to return at least to retrieve his belongings with law enforcement. I apologize, Madam Interpreter.
You're fine. You're fine. Okay. Thank you. Quisiera pedirle a su señoría que se obtenga que se le prohíba no tener contacto violento al señor Aparicio Cortés, y debido a que él provee el sustento a su familia, que por lo menos se le permita regresar a buscar sus pertenencias personales al lugar del incidente.
And Your Honor, we haven't heard from the victim So if your honor is inclined to grant a signature bond, the state's stressing for that no contact order.
Y su señoría, como la víctima no se ha contactado con nosotros ni la hemos podido contactar a ella, pedimos que si quiere considerar una fianza bajo firma solamente sin pago, queremos pedirle que se mantenga la regla de no tener contacto con la víctima.
Okay, so it's going to be a $3,000 signature bond through the jail.
Va a ser una multa de $3,000 bajo firma a través de la cárcel.
No further contact with Bertina Diaz.
Y no tener más contacto con Bertina Díaz.
Stay away from the 9240 Fisher Road address.
Tiene que mantenerse alejado del domicilio 1940 Fisher Road.
He can go back to that address on one occasion with law enforcement to retrieve any belongings that he might have there.
Y puede regresar a ese domicilio solo una vez con un oficial de policía para retirar sus pertenencias personales.
No drugs, alcohol, weapons while out on bond.
Queda prohibida el uso de drogas, alcohol y armas durante este periodo que esté bajo fianza.
Okay. Anything further on Mr. Cortez?
¿Algo más para el señor Cortés?
Nothing further from the state, Your Honor.
Nada más de la fiscalía, su señoría.
Nothing from defense, Your Honor. Thank you.
Y nada más de la defensa, gracias.
Good luck to you, sir.
Buena suerte, señor.
Okay, thank you, Madam Interpreter. We appreciate
You're
your
welcome.
assistance.
Your Honor, I would like to check on position 7, Mr.
Okay.
De Jesus Antonio, just to make sure before I leave.
So we have already dealt with Mr. Davis,
Oh, okay.
So he was not in need of your services.
Thank you, sir. Have a good day.
Thank you. You also. Okay, and just so that we put it on the record, Ms. Kim, I got your request on Mr. Terrell, who is position number 26. So we will add his mother, Yoshdeika Hill, as someone who can co-sign for Mr. Terrell.
Thank you, Your Honor.
Okay,
Thank you.
who do we have next?
Your Honor, can we do the breakout, position 13?
Yes, we can. Okay, that's fine. So who do we need to be in the breakout room on position number 13?
ASG Backus and ASG Falk for sure.
Okay, and Ms. Gant, that's your case?
Yes, Your Honor.
Okay, and myself. So if we can put the four of us in the breakout room, please. Okay, is this Mr. Jackson before me here in courtroom 2 now?
Yes, sir.
Okay, yes, Mr. Jackson, I've had an opportunity to speak with the solicitor and your counsel in the case. It's going to be $1,000 good bond, no further contact with Ms. Huff, abide by any active martyr suspensions. We're going to have a social worker visit with you to help you with your housing situation and no drugs, alcohol, weapons while out on bond.
Yes, sir.
Brought to you, Mr. Jackson.
Does that mean I'm going home?
No, it means you gotta pay the bond.
Okay, and that name, are we ready?
We're gonna go to position number 8, Mr. Goring.
Okay.
Hey, listen, let me talk to you. I got other people to do. I'll talk to you.
We ready, Miss Grace, on that name? No, you wanted the name for the Terrell? Okay, it's Yosheika Hill. Okay, and I'm sorry, courtroom 2, tell me again, who do we have?
Position number 8, Mr. Goring.
So I have position 8 is Eric Goring.
That's correct. Mr. Goring.
Goring, good afternoon, Mr. Goring. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, good afternoon, yes.
Yes, good afternoon, sir. You have been charged in case 22 CR 006121E with battery. Is there a history, Ms. Jackson?
The defendant has 22 cycles out of New York. The defendant's last arrest was August the 2nd, 2015 for criminal contempt in the first degree and a violation of an order of protection and assault in the third degree and unlawful for imprisonment in the second degree and obstruction of government administration in the second degree and menacing in the third degree. And that was in Kings County, New York. The defendant does have prior felony convictions. They're out of New York. There was one in 2003 for possession of controlled substance with the intent to distribute, and one in 1997 for possession of controlled substance with the intent to distribute, and one in 1990 for robbery. And there are misdemeanor convictions, one in 2016 for criminal contempt in the second degree, and one in 2011 for assault in the third degree, and one in 2009 for possession of controlled substance, and one in 2002 for petty theft, and one in 2001 for larceny. Nothing in addition, Your Honor.
Thank you. Who's presenting for the state? Ms. Falk, can you help me with that?
I believe it, what was the position number, Your Honor?
We're on position number 8.
I believe that's Ms. Tortorello. I'm not sure where she is.
Oh, okay.
That is correct, Your Honor.
I see. Are we ready, Ms. Tortorello?
Is this Mr. Goring?
Yes, position 8.
Okay, that wasn't on the pull sheet, so I don't have him. That he wasn't on the original pull sheet.
Not a problem. I can handle this one. Okay, Your Honor, if you'll just give me a moment to pull this up. I think, I'm not sure. This may have been a carryover from yesterday. I mean, from Saturday, but I'm not entirely sure. Okay, so this occurred on September 12th, 2022 at 1:14 a.m. at 156 Fairfield Place in Atlanta, Georgia. That's a transition home. Mr. Beckles advised Earl Beckles, that's EARL BECKLES, advised his roommate assaulted him when he couldn't find his phone. The defendant struck Mr. Beckles in the face, causing a small scratch under his eye and a penny-sized knot to the top of his forehead. The defendant, when questioned, admitted that he and Mr. Beckles had been having issues and admitted to them getting into a shoving match. It appears that the defendant has 22 cycles out of New York, ending in 2016, and then this cycle in Georgia. Based on the number of cycles out of New York, the sheer volume of previous offenses out of New York, the state is requesting a $3,000 surety bond, a no further contact with Mr. Beckles, and a stay away from 156 Fairfield Place, no alcohol, drugs, or weapons.
Thank you, Ms. Johnston.
Thank you, Judge. Mr. Goring is employed right now. He works at the Brave Stadium. And he has lived in Atlanta for about a year, and he's lived in Georgia since 2016. The location where this happened is where Mr. Goring lives also. So we would ask if it's possible for the stay away to be for it to be a no contact order with Mr. Beckles, but they each keep to their own rooms or some sort of situation like that, so that Mr. Goring still has a place to live. I would also point out that in the paperwork I received, Mr. Goring did meet the criteria for unsecured judicial release. Based on that, we would be asking for a signature bond, Your Honor.
So this, do we know what type of boarding? I mean, is it feasible that they are not going to be able to, that they're going to be around, that they will not be able to be around each other in this type of a setting?
Your Honor, to be quite frank, the state is skeptical. It says that his roommate continued to harass them throughout the apartment, yelling at him to call his lost phone, and then physically attacked him. So it sounds like even though this is a transitional center, they are residing in the same space. And so, you know, no offense to Mr. Goring, but he, you know, if there is going to be a no further contact due to the attack on the victim on this case, then we would ask that Mr. Goring have no further contact and stay away from that location. I understand Mr. Goring will just have to make other arrangements, but I don't think that that should warrant our victim being placed in a position where he has to remain and reside with a person who physically attacked him.
And I'm not in disagreement with you, Ms. Falk. So it's going to be $1,000 good bond, no further contact with Mr. Beckles. He is to stay away from the Fairfield Place address. He can go back to that address on one occasion with law enforcement to retrieve any belongings that he might have there. No drugs, alcohol, weapons while out on bond. Ms. Johnston, your client has his hand up.
Mr. Goring, I wouldn't advise saying anything unless you have something to add as to where your room is and where his room is in this house. I don't think the judge has already made his ruling, so there's really nothing else to say at this point.
Does he, Ms. Johnson, does he need assistance with I'm not sure what type of facility this is. Does he need assistance with a social worker as far as finding other arrangements for housing? If that's something that he's in need of, I'm happy to place that in the order also, that he's to have a social worker visit.
Sure, Judge. I was going to have someone from our office, a social worker from our office, reach out to him.
Okay, so I'll put that in the order also to help him with. And if he has not made bond by the SAP calendar, we'll have a note of that on the bond. So we'll take a look at it again.
Okay, thank you.
Ms. Grace, would you please add that? Yes. Okay, who do we have next?
We have position number 11, Mr. Hardy. Position number 11.
Okay. Good afternoon, Mr. Hardy. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Hardy, you've been charged in case 22 CR 006-143Y with driving under the influence of alcohol as safe, speeding, and willful obstruction of a law enforcement officer. Is there a history, Ms. Jackson?
The defendant has one prior cycle. The defendant's last arrest was July the 24th, 2012 for an assault. That was in Jacksonville, North Carolina. That charge was dismissed August the 20th, 2012. Nothing in addition, Your Honor.
Okay, Ms. Tortorella.
Yes, Your Honor. For the DUI, let's say the $5,000 surety bond. For the speeding, a $500 surety, and for the obstruction charge, a $500 surety. So that'll be a total of a $6,000 good bond. The conditions is no driving, no drugs or alcohol, no weapons, and no new violations of Georgia law. Your Honor, this occurred on 9/11/2022. The accused was checked by the Alpharetta Police Department on an XLR laser at 94 miles per hour in a posted 65 miles per hour zone on Georgia 400 northbound at Haynesbridge Road at 2:58 a.m. The accused possessed bloodshot eyes, the odor of an alcoholic beverage emitting from his breath, slurred speech, and a slow body and eye movements. So that's for the DUI and speeding. As far as for the obstruction, the accused physically resisted arrest by refusing to get out of his car and then tensing up. He had to be pulled out of the driver's seat, and then he tensed up again, not putting his hands behind his back after being told by officers to do so due to the arrest. He was still resisting after being told to put his hands behind his back. An armbar takedown was attempted by the officers, but failed due to running into the car. The other officers actually had to use their body weight to get him to the ground and get his hands behind his back. And then the officers were able to arrest this defendant. And all these events occurred in Fulton County, Georgia. Your Honor, this, though very minimal history, he is a multi-state offender, one cycle out of North Carolina, now currently one cycle out of Georgia. Again, he poses that public risk to public safety. And for that reason, we're asking for that $6,000 surety bond with the condition stated. Nothing further.
Ms. Gant.
Thank you, Your Honor. Mr. Justin Hardy is 34 years old. He has been in the Atlanta, Georgia area for 2 years. He has family in Columbus, Georgia, and also Noonan. Mr. Hardy obtained a high school diploma, and he also has a bachelor's in business administration. He is in the process of starting a new job at Progressive Lighting. He is supposed to start this week, and prior to obtaining this position, Your Honor, he worked at APAC for 2 years. Your Honor, my client strongly denies the allegations. He stated that when the officer pulled him over, just within seconds of pulling him over, he states that the officers actually slung him out of the car and wrestled him to the ground. He has bruises on his arms and legs as a result of this forceful arrest, Your Honor. I am requesting a signature bond on Mr. Hardy's behalf. According to the report that I received, he is eligible with regard to the state's contention that he is a multi-state offender. Your Honor, the history that I heard is that he had an assault charge in North Carolina that was dismissed, and he, of course, is presumed innocent in this matter. If Your Honor determines that he is ineligible for a signature bond, then I would ask for a split bond. And for the split bond, Your Honor, I'm requesting a $1,000 surety bond for the DUI and signature bonds for counts 2 and 3, speeding and willful obstruction of a law enforcement officer. And we are opposed to the no driving condition. We would ask that he be allowed to drive in accordance with DDS guidelines. Thank you, Your Honor.
All right, for the DUI, it's going to be $1,000 good bond. For the speeding, it's going to be a $250 good bond. For the obstruction, a $250 good bond. Makes for a total of a $1,500 good bond. No drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Hardy.
Thank you, Your Honor.
Your Honor, what was that bond amount again? I apologize.
That's all right. It's $1,000 for the DUI and $250 for the other 2 charges. So a total of $1,500 good.
Thank you. And next we have position number 6, Mr. Alfred Days. Mr. Days. Y'all sit down.
Good afternoon, Mr. Days. I'm Judge Eric Mora. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir, I do.
Thank you. You have been charged in case 22 CR 006134A with simple battery family violence. Is there a history? Ms. Jackson?
Yes, Your Honor. The defendant has 24 cycles. The defendant's last arrest was March the 17th, 2021 for battery. And that was in Fulton County. That case appeared to be still pending. That case number is 21 CR 00132-9 and the letter A. The defendant also appeared to have an outstanding hold out of Decatur, Georgia for a probation violation. The underlying charge was possession of cocaine. The date on that warrant was May the 7th, 2021. The defendant does have prior felony convictions. It's one in 2019 for possession of cocaine, one in 2004 for aggravated assault and possession of a firearm by a convicted felon, and one in 1996 for felony escape, and one in 1995 for theft by receiving stolen property, and one in 1994 for the violation of the Georgia Controlled Substance Act, an additional one in 1994 for possession of controlled substance. And the defendant does have misdemeanor convictions. So one in 2019 for criminal trespassing, and one in 2018 for forgery in the 4th degree, and one in 2017 for simple battery family violence, and one in 1995 for simple battery, and one in 1993 for possession of marijuana less than an ounce. Nothing in addition, Your Honor.
Okay, Ms. Tortorella, do you have any information on me on this open 2021 battery, the bond on that?
Yes, Your Honor. So the defendant was granted a $4,000 good bond, and it was issued on March 19th, 2021 by Judge Law. And he was ordered in that bond to have no further contact with the victim, Ashley Gaines, who is the same victim in this matter.
Okay.
So that's so it involves the same victim, Your Honor.
All right, that's what I wanted to know. Thank you. You can go ahead, Ms. Tortorella.
Yes, Your Honor. So for the battery family violence, we're asking for a $3,000 cash bond. The conditions is no contact with the victim. Again, her name is Ashley Gaines. Gaines is spelled Gaines. To stay away from 717 University Avenue in Atlanta. 1-day anger management, no drugs or alcohol, no weapons, and no new violations of Georgia law. Your Honor, this defendant poses a risk of reoffending while out on bond and intimidation of the witness here in this matter. As you've heard, he has an open case involving the same victim, Ms. Gaines. And in the prior case, she was 9 months pregnant. And she stated that the altercation turned physical when the defendant punched her in the head, leaving her with severe head pain. He is in fact in direct violation of this bond order, as it states that he had no contact with her. He's a flight risk, as you heard from pretrial. He's wanted out of DeKalb County for violation of probation. And this incident, Your Honor, it occurred on September 10th, 2022 at the incident location already stated on record. The defendant all for days did make physical contact of an insulting and provoking nature with the person of Ashley Gaines, who is the parent of their child, who's 1 year old at this time, by smacking her left hand. The defendant was arrested, and all these events occurred in Fulton County, Georgia. Other reasons why he poses a significant risk of intimidating this witness, Your Honor, they share a child together. It's a 1-year-old boy. And the facts of this matter, Your Honor, is violent act, smacking her hand, though it may not be as egregious as punching her in the head, Your Honor, it's still a violent act, and it's against the same victim. 25 cycles, Your Honor, he poses a risk of reoffending. He pled guilty to criminal trespass on May 22nd, 2019 at a Fulton County State Court. He pled guilty to possession of cocaine and obstruction out of DeKalb County Superior Court on April 24th, 2019. I believe that's the case that he has a warrant on for a VOP. March 23rd, 2018, he pled guilty to forgery in the 4th degree out of Gwinnett State Court. December 5th, 2017, he pled guilty to simple battery family violence out of Forsyth County State Court. And as you heard from pretrial 2004, he pled to aggravated assault out of Fulton County Superior Court. He also, Your Honor, just based on his history, the history with the victim in this matter, the facts of this case and the case before, we are asking for that $3,000 cash bond with the conditions already stated. Nothing further.
Ms. McLeod?
Yes, Your Honor. My client is 47 years old. He is a native of Atlanta. He is employed, Your Honor, and has been employed at the same job for approximately 2 years now. He is the father of a 17-month-old son. That's the only child that he has. And he tells me that he's actively involved in his child's life. I acknowledge his history, Your Honor, but he still maintains the presumption of innocence here. He tells me that he was the one who called the police because Miss Gaines attacked him. And he denies striking her or touching her inappropriately. And he says he called the police and he was surprised that he ended up being arrested because he had done nothing wrong. My client is not in a position to pay anything towards a bond, Your Honor. He tells me that he doesn't even have a place to live. He's trying to get a place to live so that he can get custody of his son because that's his only child. And that's a huge concern of his, Your Honor. So I would ask the court to take that in consideration in setting a bond for him. He does have a job that he will have if he gets out of jail. Thank you, Your Honor.
Okay, Ms. McLeod. Anyone that's been in my court before knows that what I really don't take kindly to is violating a court order, a previous court order. And I always make it known what no contact means. If he had done nothing wrong, as you said, Ms. McLeod, that's fine, but he was under a court order to have no further contact with Ms. Gaines. Had he not, and he had no further contact with Ms. Gaines, he wouldn't be in the situation that he's in right now. So just so you can hear this from me, Mr. Days, no contact means no contact whatsoever. It means no physical contact. It means no email contact. It means no social media contact. It means no contact whatsoever. And this was apparently ordered the last time that you were in court with Ms. Gaines by another judge. And had you followed that order, you wouldn't be sitting here in this situation with these allegations against you. So just so you know it from me, no contact means absolutely no contact, and you're not allowed to have any further contact with Ms. Gaines whatsoever. So it's going to be a $10,000 good bond, no further contact with Ms. Gaines. Stay away from the 717 University Avenue address. If he has belongings at that address, Ms. McLeod will allow him to go back there on one occasion with law enforcement to retrieve any of those belongings.
He actually doesn't live there.
Oh, okay. And well, if he doesn't need an escort, then he doesn't need to retrieve any belongings.
No, he doesn't.
And no drugs, alcohol, or weapons while out on bond. All right. Good luck to you, Mr. Days.
Thank you, Your Honor. Your Honor, that concludes my business before the court today. May I be excused?
Yes, I'll see you next time. Good to see you, Ms. McBrown.
Good to see you too, Judge. Thank you.
Next, we got position number 1, Mr. Allen, James Allen.
All right. Good afternoon, Mr. Allen. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir, I do.
Thank you. You have been charged in case 22 CR 006117Y with 2 counts of theft by taking. Is there a history, Ms. Jackson?
The defendant has 3 cycles. The defendant's last arrest was July the 5th, 2022, for criminal damage to property in the 2nd degree, cruelty to animals, and obstruction of an officer, and that was in Fulton County. The defendant does appear to have an open case pending in Fulton County for carrying weapons on a school property. That case number is 22 SC 181368. Defendant appear to have an additional open case pending in Fulton County for criminal damage to property in the second degree and cruelty to animals and obstruction of an officer. That case number is 22 CP 210407. Nothing in addition, Your Honor.
Thank you, Ms. Tortorella.
Yes, Your Honor. Currently, this defendant has, for the two charges of theft by taking, he has a bond set at $1,500 surety bond for each charge. We're asking that bond to increase for each charge to a $3,000 surety bond. That'll be a total of a $6,000 surety bond. The conditions is no contact with the victims. Their names, Alish Jackson. The first name is ALIS as in Sam, HE. Jackson, traditional spelling. The second victim's name is Nia Plainen. First name is spelled N as in Nancy, IA, and the last name is P as in Peter, LA, N as in Nancy, IN. To stay away from the Super Rica store at 1130 Avalon Boulevard in Alpharetta. An anti-theft class, no drugs or alcohol, no weapons, and no new violations of Georgia law. Your Honor, this defendant is a flight risk. He poses a risk of reoffending and a risk of committing felonies while out on bond. He's also a risk to public safety and a threat and danger to property of any person. Under case number 22 CP 210407, as you heard from pretrial, this is an open felony case where he's charged with criminal damage to property, second degree, cruelty to animals, and obstruction. The offense date was July 5th, 2022. He was granted a $6,500 surety bond. He was released on July 31st, 2022. And while out on bond for this case, Your Honor, just 2 months later, he committed this offense, which is in violation of his bond order, as it is implied by Georgia law that a defendant not violate any laws or ordinances of the state. The second felony case, 22 SC 181368, he's charged with carrying weapons on school property. The offense date is September 13th, 2021. He was granted a $10,000 surety bond, released on September 15th, 2021. And while out on this bond, Your Honor, he committed his subsequent felony offense that occurred on July 5th, 2022. And again, Your Honor, he's in violation of this bond order. This incident occurred on September 11th, 2022 at the Super Rica at 1130 Avalon Boulevard in Alpharetta. This defendant poses a significant threat and danger to the property of the victims, Alish Jackson and Nia Plainen. The officer C. Segal of the Alpharetta Police Department was dispatched to a theft call at the incident location. The officer, while on his way to the incident location, was advised that a black male about 20 to 30 years of age, wearing black pants with sparkly stripes on the side, took items from employees' lockers. Upon officer's arrival, he made contact with the general manager who stated that the suspect had taken off and was heading towards the Quick Trip off of Morris Road. Once on Morris Road, the officer made contact with the suspect, who fit the exact description given to said officer. The suspect advised the officer his name was James Allen. Officers were able to view video footage of the incident and identified the defendant Allen as the person who took all the items from the employee lockers. The items included $30 that belonged to Ms. Jackson and $102 that belonged to Ms. Plainen. The defendant was arrested, and all these events occurred in Fulton County, Georgia. And again, Your Honor, we're asking for that $6,000 surety bond with the conditions already stated. Nothing further.
All right. Mr. Allen, you can put your hand down. You have a right to remain silent. Anything you say can be used against you. Let Ms. Johnston speak on your behalf, okay? Go ahead, Ms. Johnston.
Good afternoon, Judge. Mr. Allen just turned 18 years old at the beginning of this month. He is employed right now and would be able to go back to work if he was released. And he would be going to live with his grandmother once he is released from jail. He cannot afford a bond at the moment, and his grandmother is
experiencing health difficulties. So we would be asking for a signature bond for those reasons. He has lived in Atlanta his entire life. He is not a flight risk. His whole family lives in Atlanta. He works here. I also want to point out the facts of this case. Sorry, I lost my paperwork for a moment. It states in the police report that the manager and the people at the location said that someone named Samuel Little stole the items. I also want to bring it to the court's attention that it is my understanding that all of these items were returned to the alleged victims. So for all of those reasons, we are asking that the bond remain at the $1,500, and if possible, we would like a signature bond due to his difficult family situation right now. All he has is his grandmother, and she is going through health difficulties. Thank you, Your Honor.
So
And
it's
Your-
my
and
understanding
Your
that
Honor-
the items, let me speak, Ms. Tortorella. It's my understanding that the items are cash money. Is that right? So you're telling me the cash was returned to these alleged victims? And if that's the case, where did the cash come from that was returned?
It was my understanding that it was the Apple Watch that was returned back to the person. And that's all I will say. That is as much as I know on this matter.
Your Honor, there was cash, also US currency, that was stolen, and there's no indication in the four corners of the warrant that this defendant did in fact return said cash. To add,
Was anything returned, Ms. Tortorella?
It doesn't state on the warrant, Your Honor.
Okay, and this watch, where did the watch come into play?
So, Your Honor, I would need to follow up with the officer. The officer did not make clear who the watch belonged to in the warrant. So I would have to amend the accusation in the future to add that in the accusation.
Okay, go ahead, Ms. Tortorella.
And yes, defense counsel is correct. He was identified as another individual, Samuel Little. However, again, Your Honor, I want to point out, the officer did state he fit the description, and they viewed video, and they identified this defendant as the person who stole the items. Nothing further.
Okay, who identifies someone at the 1130 Avalon Boulevard?
The officers reviewed surveillance footage
Okay,
at the scene, Your Honor, and they identified this defendant as the person who stole the items based on the footage and the description given by the general manager to the officers.
okay.
They watched the surveillance video, Your Honor.
Judge, I just want to point out the facts already stated by defense, and that we would be asking for the signature bond based on those facts being difficult. And my client does say that the items were returned to the victims.
All right, it's going to be a $500 good bond for each charge, making it a $1,000 good bond. No further contact with Ms. Jackson and Ms. Plannon. Stay away from 1130 Avalon Boulevard, and no drugs, alcohol, or weapons while out on bond. If Mr. Allen is still in custody at the SAP calendar on the 22nd, I'll take a look at this. At this bond. All right, good luck to you, Mr. Allen.
Next, we have position number 3, Mr. Carson.
Good afternoon, Mr. Carson. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. You have been charged in case 22 CR 006119A with battery family violence. Is there a history, Ms. Jackson?
The defendant has 10 cycles. The defendant's last arrest was March the 11th, 2022, for a probation violation in Fayette County, Georgia. The defendant appeared to have an open case pending for theft by taking in Fulton County. This looks like a reference number, F21 PF 005388. In addition to that, the defendant appeared to be on probation in Fayette County, Georgia, for identity fraud. That disposition date was September the 1st, 2021, and the term is for 5 years. The defendant does have a prior arrest in 2002 for simple battery. There was no disposition for it. The defendant does have a prior felony conviction. It was in 2015 out of Cherokee County for financial or transaction card fraud. And the defendant has a misdemeanor sentence that was in 2014. The defendant received a nolo contendory sentence for driving while license suspended or revoked and giving false information to an officer. Nothing in addition, Your Honor.
Thank you, Ms. Tortorella.
Yes, Your Honor. For this case, we're asking for a $3,500 surety bond. The conditions is no contact with the victim, Miss Bernice Hearn. The first name is spelled B as in boy, R-E, N as in Nancy, I-C-E. Hearn is spelled H-E-A-R-N as in Nancy. To stay away from 2315 Glenwood Avenue in Atlanta. Glenwood is spelled G-E-G-L-E, I'm sorry, N as in Nancy, W-O-O-D. 1 day anger management, no drugs or alcohol, no weapons, and no new violations of Georgia law. Your Honor, this incident occurred on September 10th, 2022 at 2315 Glenwood Avenue in Atlanta. This defendant poses a significant threat and danger to the person of Bernice Hearn. The defendant, Charles Carson, did intentionally cause bruising to Bernice Hearn, who is his present spouse, by grabbing her right arm in a forceful manner. The defendant was arrested, and these events occurred in Fulton County, Georgia. Your Honor, this defendant also poses a risk of intimidation of this victim. It's foreseeable defendant will intimidate due to the actions taken in this matter, as well as the fact that they are married, and he has a violent history in his criminal history. In 2010, he was arrested for robbery by sudden snatching and aggravated assault by the Atlanta Police Department. That's a dead docket. And in 2002, he was arrested for simple battery, terroristic threats by the APD. And this case was not presented to the grand jury. May I remind Your Honor, he is currently on probation in Fayette County. On March 11, 2022, he violated that probation and was ordered to continue on his original probation. You've heard from pretrial as well that he was also recently convicted of a felony in 2015. And for that reason, Your Honor, we are asking for that $3,500 surety bond with the conditions stated. Nothing further from the state.
Ms. Johnston.
Yes, Judge, we would be asking for a $1,500 bond on this case. That is what Mr. Carson can afford. He does currently have a job. He works in security and he can go back to work if he was to be released. They do also currently have separate residences, so he would be able to, he would have a place to stay if there is a stay away order in this case. Nothing further from defense, Your Honor.
Does he need to go back to the Glenwood Avenue to retrieve any belongings?
I don't believe so, Your Honor.
Okay.
And I think he's shaking his head right now.
All right, so it's a $1,500 good bond, no further contact with Ms. Hearn, stay away from the Glenwood Avenue address, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Carson.
Y'all, who's that bond amount?
1,500 good.
Thank you. We're completed here in courtroom 2. May we be excused?
Oh, that's it? Okay.
That's it.
Yep, we'll see you all tomorrow.
Thank you.
All right, have a good one.
Good afternoon, Your Honor.
Yes.
Stock Annex, position number 23, Ms. Robinson.
Good afternoon, Ms. Robinson. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, ma'am.
Okay, you've been charged in case 22 CR 006128F with battery family violence. Is there a history, Ms. Jackson?
The defendant does not have any prior arrests on file, Your Honor. Nothing in addition.
Okay, Ms. Falk.
Your Honor, by way of explanation, it looks like the defendant was arrested on this case on September 8th, was in East Point Jail, and then transferred here to the Fulton County Jail. For that reason, we are requesting a $3,000 signature bond through pretrial services with a co-signer on bond since she is under the age of 18. Stay away order from 2615 Delow Drive, East Point, and no further contact with AL, as well as 1-day anger awareness, no alcohol, drugs, and weapons. So this happened, as I stated, on September 8th. Miss Lark, who is the mother of the 9-year-old AL, stated that the defendant, who was 17 years of age at the time, slapped her 9-year-old daughter in the face. The parties all lived together at the residence. AL, when the officers did get a chance to speak to the child, AL, and I will put the child's name in the chat, to Your Honor, and to the litigation manager, as well as Ms. Kim. When AL stated that she asked the defendant to play with her, the defendant kicked her in the back, told her to get out and leave her alone. AL then threw a remote at the defendant, who got up and began hitting her and struck her in the face very hard. The officers actually saw red marks on the side of the child's face in the shape of a handprint. The defendant admitted to striking AL in the face, but stated she didn't realize how hard she had hit her. So for only the reason that the defendant has been in custody since September 8th, and this is the first appearance that we had, we are requesting that signature bond.
Ms. Falk, who is AL's mother to Ms. Robinson? Do you know?
So it appears it's a god sister relationship, and let me just double check and make sure I'm not speaking out of turn, but there is I believe it's a god sister relationship. I just want to double check.
All right. Ms. Kim, is there someone who can co-sign for Ms. Robinson?
Yes.
Who would that be?
Stepfather Lee Morris, Lee, last name Morris. But since he's driving a truck today, all his utility bills are in his name. The mother can come and co-sign as long as she's allowed to bring husband's utility bills in his name.
Where does he live? Where does he live, Ms. Kim?
The mother, Tisha Robinson, Tisha Robinson. That's Miss Robinson.
No. I mean, where is Miss Robinson going to live once she is out of custody?
Well, she resides with godmother and godsister 2615 Deloy Drive.
So she's not okay. So she's not going to be able to go back there. So where is she going?
Mother's place.
Is that a question or is that a statement to the court?
It's actually a question. I'll have to double check with.
Can I speak, please?
Okay. Is this Miss Lark that wants to speak?
I believe so, Your Honor.
All right, so Ms. Lark, okay, hold on, Ms. Lark. I'm happy to let you speak, but first I'll have to get you to identify yourself, and then I'm gonna have to get you to swear you in.
Okay.
All right, so who are you, Ms. Lark, to this case?
She's my goddaughter. I have temporary custody of her right now.
Okay, and you are AL's mother?
Yes.
Okay, and if you'll raise your right hand for me. It appears that she's in a vehicle also, and
I think she's frozen, Your Honor. I will state for the record that Miss Lark did speak with our victim advocate. She is okay with Miss Robinson returning. However, the state is not, given the circumstances.
Okay, Ms. Locke, do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? I don't know if she can hear me or not. She raised her hand.
Yes.
Okay, you're gonna have to get into a better
Hear me?
space. You're gonna have to get into a better space, Ms. Locke, because we can't understand you, okay? Keep going in and out. And if you are driving a vehicle, I'll need for you to pull that vehicle over to the side of the road while you talk with the court.
I think we lost her. Yes, I don't see her on the line anymore, Your Honor.
South Annex, do we have somebody else we can go to?
Yes, sir. Position number 14. Ms. Jones.
Okay, good afternoon, Ms. Jones. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that were conducted by video. Do you agree to have your case heard by video?
Yes.
Thank you. You've been charged in case 22 CR 006123D with battery family violence. Is there a history?
Defendant does not have any prior arrests on file, Your Honor.
Okay, Ms. Bacchus.
Yes, Your Honor. The state is recommending a $3,000 surety bond, no further contact with the victim, Marquez Stevens. That is Marquez. Stevens is with a PH. Stay away from the incident location, which is 36 Macon Place Southeast in Atlanta. 1-day anger awareness, no alcohol, drugs, or weapons. This incident occurred on September 10th. Officers were dispatched to a domestic dispute call at that incident location. Upon arrival, the officers approached the residence where they could immediately hear yelling coming from an open window. Another resident stepped outside and said that she called to report that a male and female were fighting on the scene. When approaching the home, the officers gave verbal commands and advised the individuals fighting to step out, at which time they detained both parties. And upon speaking with the victim, Mr. Marquez Stevens, he stated that he lives at the location with the defendant. They're dating, bless you, Your Honor, and that they're dating, and he wasn't wearing a shirt. And so officers were able to see that he had bruising on his neck and bite marks on his torso. And so when he asked how he got them, he said that the defendant is the one that gave them to him. We are aware that she does not have a history, Your Honor, but we are concerned about the violent nature of this offense. And we also, the no further contact, we do feel that there needs to be more of a cool down period. And so we are asking for that no further contact, and we definitely don't want her back at that incident location in the interim. Nothing further.
Has your office spoken with Mr. Stevens?
Let me look at my notes 1 second.
And while she's doing that, Ms. Gant, you can go ahead.
Thank you, Your Honor. Ms. Shakira Jones is 17 years old. She has been in the Atlanta, Georgia area her entire life. She does have family here, including her grandmother, Ms. Deborah Carr, who is her guardian. Ms. Carr informed me that she will be willing to co-sign for Ms. Jones, given her age. Ms. Jones completed, well, currently she is a student, a 12th grader at South Atlanta High School. She makes A's and B's. She's also currently employed at Wendy's and has been working for the past 2 years. Your Honor, she denies the allegation. She states that she was merely acting in self-defense. She stated that Mr. Marquez Stevens, the complaining witness, choked her and that she was merely defending herself. Now, regarding contact, my client wants to continue having contact. I did reach out to Mr. Stevens. I'm happy to place his number in the chat. He states that he could not join the Zoom call because he does not have the court's indulgence, please.
Your Honor, our office did not speak with him, just to let you know. He's a minor, just as well as she is.
Okay, thank you.
Right. Your Honor, I do apologize for the interruption. going back to my argument, Mr. Stevens wants contact. He could not appear on the Zoom call. He states that he does not have access to Zoom. I also spoke to Ms. Carr. She informs me that Mr. Stevens does not live there at the incident location, 36 Macon Place. Therefore, Your Honor, I'm requesting a no violent contact order. I am opposed to the stay away as Mr. Stevens does not live there. Ms. Deborah Carr confirmed that that is her residence, and Ms. Shakira Jones lives there with her grandmother. I am requesting a signature bond as this is her first offense, Your Honor. And if Your Honor determines that she needs to stay away from that residence, I would ask for a one-time law enforcement escort so that she can retrieve any belongings.
Your Honor, the state, if that is where her grandmother lives and that's where she lives and he does not live there, we're not opposed to taking the stay away off, but we do not want, we don't want them to have contact at this point.
Okay, and I'm not in disagreement with you, Ms. Bacchus. So Ms. Gant, Ms. Deborah Carr is a grandmother. She can be the co-signer. She's also going to need a utility bill from, I guess, 36 Macon Place, if that's where she resides and where Ms. Jones is going to be residing. It's going to be a $2,000 signature bond through pretrial, 1-day anger awareness, no further contact with Marquez Stevens, and no drugs, alcohol, or weapons while out on bond.
And Your Honor, regarding the utility bill, I did mention that to Ms. Carr. She states that she may be able to print one offline. May Your Honor waive that utility bill requirement?
That's fine, Ms. Jackson. You'll have to get me that waiver.
And do I need to place the telephone number for Ms. Carr in the chat?
I think that would be helpful.
Okay, thank you, Your Honor.
Is it Deborah, D-E-B-O-R-A-H, Carr, C-A-R-R, Ms. Gant?
Correct, Your Honor.
Okay, very good. All right, good luck to you, Ms. Jones. Let me see, let's go back to Ms. Robinson. Is Ms. Law coming in?
Let me come back. I'm here.
Okay, Ms. Lark, what did you want to tell the court regarding Ms. Robinson?
I was calling back because I don't mind her coming back long as she do like counseling and anger management class because I got custody of her.
Because you are mute, Ms. Lark.
Yes.
Does she have somewhere else she can go? You said that you were the primary caretaker of Miss Robinson?
Yes, she's up here from her mom from South Carolina. I had to get custody of her from her mom, and then her dad over the road. So she primarily stay with me. I know her and my child, they play all the time, but I just said, so I wasn't even mad about the situation. I know they play a lot. And I said something to her, but her attitude and her talking back. And I was like, we had got into it about that. And so then the police ended up coming out. But I don't mind her coming back to my house as long as she abide by the rules and she go get counseling and like anger management. Because I always had it when she was a baby. Like her mom is in South Carolina, her dad is on the road, so I'm the only one that can able to sign for her because she's still under my care.
Did you call the police in this incident, Ms. Lark?
Yeah, I called because I wanted her just to leave so I won't get that far, but her attitude, she was talking back. I was trying to let them see can they take her somewhere else for a meanwhile, but it wasn't intended to go that far. But I know her and my daughter play a lot all the time. They always playing about like hit her too hard, and I was talking to her about that, and she was just getting loud and stuff like that.
All right, you're breaking.
I don't mind her coming back.
Okay, so it's not only that you mind, Ms. Lark. I'm concerned about your minor child, and I'm also concerned, are you willing to co-sign for her to get out of custody, given that she's a minor?
Yes. Hello?
Yes, did you hear my last question?
You said what? You said what now?
I said, are you willing to co-sign since you are her guardian for her to get out of custody? She's a minor, so she's going to need a co-signer.
Yes. Yeah, I co-sign for her.
Okay, and it's Lashana, Lashana Lark, Lark, is that right?
Yes, sir.
And you live at, on that Delow, address?
Yes.
Okay, Ms. Funk, anything further?
Your Honor, the state reiterates our concerns here. You have a 17-year-old who slapped a 9-year-old child in the face hard enough to leave marks. So I don't know what Miss Robinson's issues are, but I don't know if that warrants you putting your hands on a child to that extent. Even if you are 17, she's 9.
And again, I don't disagree with Ms. Falk.
Yeah.
I'm going to order that she does have anger management classes more than what I normally order. So it's going to be a $3,000 signature bond through pretrial, 8-week anger awareness class, no further violent contact with minor AL or with Ms. Lark. No drugs, alcohol, weapons while out on bond. And Ms. Lark, you're going to have to co-sign for Ms. Robinson to get out of custody. And you're going to have to bring a utility bill with you, okay?
Okay, I have that.
All right, very good.
And I
Anything?
think she said she was gonna look up counseling for her as well.
I'm going to order
No.
that she has anger management. Okay?
Okay.
All right. Thank you, Ms. Lark. All right. Good luck to you, Ms. Robinson.
All right, thank you.
Say it again.
That'll be off of South Annex, maybe be a
Oh, yes. Have a good afternoon. Thank you.
too, sir.
All right, so we're back in courtroom 3.
Yes, Your Honor.
Okay, who do we have?
Position number 5, Ms. Gabrielle Cooper.
Good afternoon, Ms. Cooper. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. You have been charged in case 22 CR 006133E with battery family violence. Is there a history, Ms. Jackson?
The defendant has 2 cycles. The defendant's last arrest was April 6, 2018 for trespassing and it says not amounting to a burglary, and that was in Las Vegas, Nevada. There are no convictions in the GCIC, Your Honor. Nothing in addition.
Okay, Ms. Tortorella.
Yes, Your Honor. For the battery family violence charge, we're asking for a $4,000 surety bond. The conditions is that she have no contact with Mr. Trustin Barrett. First name is Treston as in Nancy. Last name is B as in boy, Arrett. To stay away from the incident location at 1111 Oakley Industrial Boulevard, apartment 11207 in Fairburn. A 1-day anger management, no drugs or alcohol, no weapons, and no new violations of Georgia law. Your Honor, this occurred on 9/11/2022 at the incident location, apartment 11207 in Fairburn. This defendant poses a significant threat and danger to Mr. Barrett. The officer, Jay Braxton of the Fairburn Police Department, was dispatched to the incident location in reference to domestic dispute between a couple. Upon arrival, the officer made contact with Officer Wilburn, and she advised she physically separated the defendant, Gabrielle Cooper, and the victim, Mr. Trustin Barrett, from a physical altercation where the officer only observed Mr. Barrett and the defendant on the ground holding each other's hair. After speaking to Officer Wilburn, the responding officer made contact with defendant, who denied there was any physical altercation between herself and Mr. Barrett. The officer did not observe any visible injuries on the defendant's person. Mr. Barrett stated to officers that they were arguing about a text message. Mr. Barrett advised he went to his neighbor's, Mr. Mark Shaw's residence at apartment 11209 to end the argument, but Ms. Cooper followed him to the residence. The officer observed a large bloody laceration on the chest, collarbone area of the victim and several bloody lacerations on both sides of Mr. Barrett's neck. The officer then made contact with Mr. Shaw, who was hesitant to speak, but regardless stated Mr. Barrett attempted to terminate the verbal argument, but the defendant followed him and became more irate. Mr. Shaw advised Ms. Cooper was the aggressor and showed the officer video on his phone of the altercation in the breezeway. The officer observed on the video Ms. Cooper straddling on top of Mr. Barrett, striking him in the face multiple times and screaming at Mr. Barrett. Mr. Barrett did not strike Ms. Cooper at any time in the video. The defendant was arrested, and all these events occurred in Fulton County, Georgia. As far as intimidation of witness, Your Honor, the officer stated Mr. Barrett became vague about Ms. Cooper entering Mr. Shaw's residence. He was hesitant to talk about the incident. Mr. Barrett did not want to speak in regards of the injuries. During the altercation, Your Honor, the officer observed on the video Mr. Barrett covering his face throughout the entire altercation, begging for Ms. Cooper to stop hitting him. Your Honor, we had contact with the victim. We asked the victim if this has happened before. The victim was very vague with his answer and did not give a direct yes or no to the victim advocate. The victim stated that he wants contact with her and wants her to return back to the home. Your Honor, this defendant's a multi-state offender. What I got from GCIC is that she was arrested for burglary, Las Vegas, by the Las Vegas Metropolitan Police out of Nevada in 2018. Again, Your Honor, we're asking for no contact with Mr. Barrett, even though we understand that the victim wants contact, just given the facts of the matter, Your Honor. We are concerned for the victim's safety, for her to stay away from the incident location and all the other conditions already stated on record. Nothing further.
Ms. Johnston.
Oh, sorry. Ms. Cooper currently works as an esthetician. She has submitted all of her licensing requirements to the state board and is waiting on them to send it back right now. She has only lived out here for a few months. She lives out here because her mom bought a house and her sister is pregnant, so she's close to her family here, and that's what brought her to the Atlanta area. My client, Ms. Cooper, does assert her innocence in this matter. She was only defending herself against the alleged victim in this case. And because of those facts and her criminal history, we would be asking for a signature bond on this case.
And Your Honor, the victim's on the Zoom hearing as Mr. Garrett Barrett. Not sure if Mr. Barrett wants to speak.
Yeah, I'm here.
All right, good afternoon, Mr. Barrett. If you would like to address this matter, I need for you to raise your right hand.
Yeah, I never called the police.
Okay, did you hear what I said?
Sorry, I'm sorry.
You're fine. Do you
Yeah, I
swear?
do.
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. What would you like to tell the court, Mr. Barrett?
Like I was saying with Gabrielle Cooper, everything we've been rocking for well over a year. Never had no issue like this. It's the first time an issue like this has happened. We just moved here. I just started working out here, and she's about to start working too. So that's the. It's been crazy for the two of us. We've been stressed out a lot. And me personally, like I didn't even look at it nothing that crazy as everybody's playing it out to be.
Did you call the police, Mr.
No, sir.
Do you live at the Oakley Industrial Boulevard address?
Yes, sir.
And does Ms. Cooper live there with you?
Yes, sir.
Are you afraid of her?
No, sir.
Okay. Anything else?
Yeah, I would just like y'all to go really like her. She doesn't have a criminal background, and she really does what she has to do here. So I know it was like a one-time. It was one argument that we had get a little out of hand, and some of the neighbors may have took it a little out of judgment a little bit.
All right, thank you, sir. Is there anybody else on that wants to speak on this matter?
No, Your Honor.
Your Honor, the state would like to question its witness, Mr. Barrett.
Go ahead, Ms. Tortorella.
Mr. Barrett, how are you?
How you doing? I'm good. How yourself?
Good, thank you. I understand that you didn't call the police. However, did you suffer any injuries due to this altercation?
No, I've been fine. I just, like I said, we just talked. We were just talking a little bit. The argument escalated a little bit. I'm walking off. She wants to talk. So it's like a late scratch. Like she's just trying to pull me back to talk, and she scratched me. It wasn't nothing like she physically struck me or anything like that.
Did you bleed?
Nothing like that. It was a light scratch, like a light break in the skin. That's it.
Did Mr. Shaw provide video to the officer about what occurred?
I'm not sure. I'm really not sure.
Nothing further for this witness, Your Honor.
Okay. It is going to be a $2,000 signature bond for pretrial, one-day anger awareness, no further violent contact with Mr. Barrett, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Ms. Cooper. And you also, Mr. Barrett.
Thank you, Judge. Have a good one.
All right, have a good afternoon. Who do we have next? Say it again. Number 9, Ms. Greco. Good afternoon, Ms. Greco. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're holding by video. Do you agree to have your case heard by video? Thank you. You've been charged in case 22-CRI-006137G with a false report of a crime. Is there a history, Ms. Jackson?
The defendant has 2 cycles. The defendant's last arrest was October the 22nd, 2021 for possession of controlled substance. And that was in Suffolk County, New York. The defendant has 1 misdemeanor conviction that was in 2021 in New York for possession of controlled substance. Nothing in addition, Your Honor.
Ms. Tortorella?
Yes, Your Honor. We did offer, we are offering time served for this case, Your Honor. It's only good for this calendar. I'm not sure if defense was able to, I emailed your coworkers, Ms. Gant, Attorney Gant, and Attorney Kim. I'm not sure if that got to you, Attorney Johnston.
It did get to me, but it got to me a bit too late for me to give it to my client.
Okay.
Do you want to talk to your client on the phone?
I don't need to. I wouldn't advise her to take a plea to this anyway, based on the facts. We were going to ask for a signature bond if we could go through that.
Okay, tell me what the facts are, Ms. Tortorella.
Yes, Your Honor. This incident occurred on 9/11/2022 at 9995 Old Dogwood Road in Roswell. The defendant, Kayla Greco, did willfully and knowingly file and cause a false report to be given to a law enforcement officer of the Roswell Police Department at the incident location. The defendant originally reported to Roswell Dispatch that her boyfriend was in danger because he owed money to a subject, later identified as Mentwan Matlock. The defendant reported that Mr. Matlock went upstairs to his room, and then she heard shots and that she knew Mr. Matlock had a gun. The defendant reported that Mr. Matlock went upstairs to his room, and then she heard shots. While on scene, defendant reported that she never heard a gunshot. So when the officer was on scene, she changed her story. Defendant reported that she never heard a gunshot before and that she got scared because she heard loud noises, quote, bang, bang, end quote. Officer on scene spoke with the hotel's front clerk and cleaning service employees who advised they did not hear gunshots. A defendant changed her statements on multiple occasions with the responding officer. The defendant was arrested and all these events occurred in Fulton County, Georgia. Your Honor, just for the record, we did dismiss the case involved because Mr. Matlock was also arrested, so we dismissed his case due to what occurred here and the facts. We have good facts here to continue to prosecute this case. So we are asking for the $1,000 surety bond to change to a $3,000 signature bond through pretrial services. The condition is no contact with Mr. Matlock, no drugs or alcohol, no weapons, and no new violations of Georgia law. Nothing further.
Why are you requesting a no contact? And I just want to say, Mr. Matlock is in court with me and wants to speak on this matter at some point. So I'll give him that opportunity.
Well, it seems that, Your Honor, I'm gonna have to stay on record. So it seems like her boyfriend, that's his dealer. So she has contact with him, and the fact that he gave a false report of a crime against him and he ended up in jail for it, Your Honor, we're asking just for no contact at all. I understand this is not a violent offense, but I'll leave it to Your Honor's discretion.
Ms. Johnston?
Judge, we would object to that based on the state's reasoning just now, but I'm not sure if my client has an issue with no contact order with Mr. Matlock. I'm not sure if that would affect her. I think she's shaking. I can't tell if she's shaking.
Can you unmute courtroom 3?
And to add, Your Honor, she did
Hold
say
on for me, Ms. Tortorella. There's too much information coming at me at one time, so give me a moment. Courtroom 3, can you unmute? Officer Middleton, are you there? Okay. So the question was, do you want contact, Ms. Greco?
Do I want contact?
Yes.
No, it doesn't matter. It doesn't matter. It's okay.
Huh. All right, Ms. Johnston, anything further?
Judge, we have no issue with the signature bond the state is asking for, so we're in agreement about that.
Okay. Mr. Matlock, do you want to be heard on this?
I'm her boyfriend.
Okay, I understand that, but do you want to, is there anything that you want to say in regards to this matter?
Yeah, when I got
Okay, if you do, I'm gonna have to swear you in and you have to come over here to the podium. All right, can you raise your right hand for me?
Yeah,
You swear from the testimony you're about to give before
I swear.
be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, put your hand down and state your name.
My name is Carlos Munoz.
Okay. Can you spell that for me?
Carlos Munoz, Munez.
M-U-N-E-Z?
Yes.
Okay, before you go ahead, Ms. Tortorello, I thought you gave me a name of Madlock.
Matlock, Your Honor.
Spell that?
What we have in the warrant is M-A-T-L-O-C-K.
Okay, Matlock. I have Mr. Munoz here, so I don't know if that's the same person or not the same person that you're asking for a stay away in regards to.
No, I'm asking for the person involved. He was also arrested, Your Honor. Juan Matlock.
Okay, well, that's not who this person says that he is.
I'm her boyfriend. I'm Greco's boyfriend.
Okay, all right. And what would you like to tell me, sir?
Nothing, like everything I saw. I spoke to the detective yesterday when I got at the hospital, and they were the ones that told me to come to court because he was gonna get released. I got out tickets to go back to New York, and that's why I'm here. I'm here ready to pick her up to take her back home. We're going back home. We're not staying in Atlanta.
Okay, all right. Anything further, sir?
I don't know my way around, so I don't know if I should wait here for her or where can I pick her up at? I have no idea.
Well, she's not gonna be here, so she's gonna be at Rice Street. So we can get you the information regarding that, okay?
Okay.
All right, thank you,
And
sir.
you have her just, that way she can wait for me there for where I can pick her up.
Well, she'll be, if she gets a signature bond, which she is gonna get, she's gonna be released. I'm not sure when she'll be released, but as soon as she gets processed out.
Okay, do she want me to pick her up?
I don't know if she wants you to pick her up or not.
Okay.
And Your Honor, we're gonna change our recommendation, given the fact that, her boyfriend has just stated on record that she lives in New York. They're gonna go back to live to New York. She poses a flight risk, Your Honor, to come back to court. So, we were asking that signature through pretrial, Your Honor, but however, we're asking for that bond amount to remain the same, which I believe was that $1,500 surety bond.
We can stay.
We don't even know, I mean, you have Matlock, you have Munoz, you have.
Yeah, we can stay if I have my job.
Okay, you're good, sir. Okay, so I'm gonna give you a signature bond. I'm gonna give her a signature bond. It's gonna be $1,000 signature bond through the jail. And I don't even know who Matlock is, so.
He's not before you, Your Honor. He's the boyfriend who is involved with her. And
I don't have another boyfriend.
Your
but
Honor,
him.
he was on the poll sheet this morning, but I believe we know across his charge.
Not Matlock, not Munoz.
No,
nor do we have
Matlock was no cross this morning. Matlock was.
Matlock is not her boyfriend. Matlock is
Okay,
a drug dealer.
Hold on, Ms. Falk.
Yes, Your Honor. I believe I can assist here because I think we're just getting a little off track. So Munoz is the boyfriend of the defendant, who the defendant called the police and said that Matlock was threatening Munoz, her boyfriend, with a gun and was shooting. It turned out that that statement was false, but in the process, Matlock, who was the person she accused of having a gun and shooting because, and I am quoting the warrant here, he's Black and from Chicago. It turns out that he was then arrested because when the police tried to make contact with him, he walked away from the police. And so they arrested him for willful obstruction, which I then had dismissed because there just was not sufficient probable cause there to arrest him for willful obstruction for walking away when he had not committed an offense. And it turned out that the report that this defendant gave was false. After looking at the warrant, I see that she is from New York. And so had I been aware of that, we would not have recommended a signature bond because there are always concerns when someone goes off to another state and there's no surety bond holding them, that they may not be inclined to come back.
Okay, anything further from anyone? All right, it's gonna be a $3,000 signature bond through the jail, no drugs, alcohol, or weapons while out on bond. Good luck to you, Ms. Greco. Good luck to you too, Mr. Munoz.
Thank you, Your Honor.
You're welcome.
Next, we have petition 21, Ms. Odom. Yes.
Your Honor, that's all I had before you this afternoon. May I be excused?
Are you sure you don't want to stay till the end of the calendar, Mr. Johnston?
It's really hard for me to leave, but I think I'm gonna have to.
Have a good afternoon. Good to see you.
Thank you, to Your Honor.
All right, good afternoon, Ms. Odom. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
I do, Your Honor.
All right, you've been charged in case 22 CR 006141B with simple battery family violence. Give me just 1 second. Okay, I'm sorry. You have been charged in case 22 CR 0061413 with simple battery family violence. Is there a history, Ms. Jackson? I'm sorry.
The defendant has 5 cycles. The defendant's last arrest was December the 26th, 2006, for driving while license suspended or revoked. That was with the City of Atlanta Police Department. Those charges were dismissed on January the 17th, 2007. The defendant does have 1 misdemeanor sentence. It's in 2005. The defendant received a nolo contendere sentence for driving while license suspended or revoked. Nothing in addition, Your Honor.
Thank you, Ms. Bacchus.
Yes, Your Honor. The history is so remote, and so minor. The state is amenable to a signature bond, a $4,000 signature bond. We are recommending no further violent contact with the victim, Cedric Bennett, and a 1-day anger awareness course. Essentially, officers responded to a dispute call at 259 Boulder Park Lane in Atlanta, and upon arrival and after further investigation, the limited information that we have is that the officer ascertained that the defendant was the primary aggressor. She basically, I think she slapped her boyfriend, but they have been together and living together for 17 years, Your Honor. And so we're not opposed to that signature bond. Nothing further from the state.
Okay, it's going to be a $2,000 signature bond through pretrial, 1-day anger awareness, no further violent contact with Mr. Bennett, and no drugs, alcohol, or weapons while out on bond. Does that suit you, Ms. Kim?
Yes, Your Honor. Thank you.
Okay, good luck to you, Ms. Odom.
Thank you, Your Honor.
Thank you, Your
You're
Honor.
welcome. Who do we have next?
Did we do position 17, Your Honor?
17?
Yeah.
Okay, this is Ms. Leftwich.
Yes, Your Honor.
Okay, good afternoon, Ms. Leftwich. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. You have been charged in case 22 CR 0061258 with simple battery family violence. Is there a history, Ms. Jackson?
The defendant has 14 cycles. The defendant's last arrest was May the 1st, 2022 for DUI, and that was in Snellville, Georgia. The defendant appeared to have an open case pending in Gwinnett County for DUI. And the defendant also appeared to have an open case pending for battery family violence and cruelty to children in the 3rd degree in DeKalb County. The defendant was arrested for battery in 2012, but that charge was dismissed. The defendant received first offender treatment in 2001 out of DeKalb County for theft by taking. That case was sealed July 6, 2017. The defendant does have misdemeanor convictions. There's one in 2017 for theft by shoplifting. One in 2018, the defendant received a nolo contendere sentence for driving while license suspended or revoked. And the defendant, there was one in 2015 for 3 counts of theft by shoplifting. And the defendant received a nolo contendere sentence in 2004 for deposit account fraud. Nothing in addition, Your Honor.
Thank you, Ms. Bacchus.
Yes, Your Honor. This incident occurred yesterday. An officer was dispatched to 1423 Saratoga Drive in reference to a domestic dispute. Upon arrival, the officer spoke with Ms. Sylvia Reed, who explained that her friend, who is the defendant, and her children were staying with her as they were recently evicted from their home. The defendant had departed prior to the officer's arrival, but Ms. Reed explained that she said the defendant had come to the house to retrieve some of her property. And at that time, she began, I guess, yelling at the victim, who is Jalen Butler. I believe that's her 23-year-old daughter. One of the minor children explained that while his mother was basically cussing him out, she also punched him in the face and hit him in the back. But because he had no visible injuries at that time, the officer said he didn't have enough probable cause, and so he left. However, later, the defendant then called the Roswell Police Department and spoke with the officer and said that she wanted to return to Miss Reed's home, to pick up her children as she had acquired a temporary residence at the local extended stay hotel, and she demanded that her 12 and 14-year-old sons come back to the hotel with her. So when the officer returned to Miss Reed's house, he basically told her and the two minor children that they would have to return to the defendant's custody. At that time, one of the sons demanded and begged the officer that they did not want to go with their mother because they felt unsafe. And so one of the minor children then showed the officer a video of the incident that had occurred with the victim in this situation. And sorry, one second. So showed the officer the video, and basically what the officer observed in the video was that the defendant stood up and got in Jalen's face and was yelling, "You want to fight me?" And then she pushed her on her neck in a violent manner, and that's when the other family members jumped in and pulled the defendant off of Miss Butler. And so after viewing the video, the officer was able to establish probable cause, and that's when he arrested the defendant. Now, we did speak with the victim, who basically said that the defendant has been violent with her since she was a child, and there were other cases involving violence when she was in high school. She also stated that there's a current open defects case out of DeKalb with her two little brothers, and that the defendant also hit the brother, which he said to the officer in this same incident. She said the defendant has a drinking problem and needs help with her drinking, and that she was drinking when this incident occurred. And the daughter also stated that the incident is that Miss Reed's home and that she's not allowed back there either, and that none of them want contact with her. She should be on the Zoom. Her name is Jalen Butler. If you want to call for her, Your Honor. But the state's recommendation in this case is a $5,000 surety bond, no further contact with Jalen Butler, 1 day anger awareness, and no alcohol, drugs, or weapons. And that's really based on the fact that there's that open defects case, and based off of what the victim said, the history of what has occurred in this family, and what the witness said, Miss Reed. Nothing further, Your Honor.
So Ms. Baca, Saratoga Drive, whose address is that?
That is Miss Reed's address. That is where they were staying.
Okay, so are you asking for a stay away from that address?
Yes, sorry, that wasn't on there. I apologize. Yes, Your Honor.
Okay, and so, and where is Jalen Butler? Is he at Miss Reed's address?
That's actually the 23-year-old daughter, and she was there that day. I'm not sure if she lives there. Yes, she lives there, according to our victim witness advocate.
Okay, and Miss Butler, I don't see her on the line.
Okay.
So, and you want no further contact with Miss Butler and Miss Reed?
Yes, I mean, the stay away, yes, I guess so. The stay away would be sufficient, but she does not want her at that location.
Okay, Ms. Garrett?
Thank you, Your Honor. Miss Ebony Leftwich is 40 years old. She has been in the Atlanta, Georgia area her entire life. She has 4 children. The complaining witness, her daughter, who's age 23. She has the 2 minor children, ages 15 and 12. She also has a 19-year-old in college, Your Honor. She is not receiving any child support. Ms. Leftwich has an associate's degree in human resources. She just started a new position at Enter Parfum. Your Honor, she denies the allegations. Regarding the video, she states that her son began recording after her daughter, Ms. Butler, and the witness, Ms. Reed, attacked her. So she states that, that video is certainly biased, Your Honor. I heard about my client's history. However, I did not hear about any convictions for violence. She is presumed innocent in any open cases as well as this one. I am requesting a signature bond on Ms. Leftwich's behalf. And if Your Honor determines that she is ineligible, I would ask for a bond of no more than $1,000. And regarding the conditions, my client does not want any contact with Ms. Butler nor Ms. Reed. We are unopposed to the stay away. However, we would ask for a one-time law enforcement escort at the incident location, as Ms. Leftwich informs me that she does have belongings there. And that concludes my argument, Your Honor. Thank you.
Thank you. It's going to be a $3,000 good bond, no further contact with Ms. Reed or Ms. Butler, stay away from the Saratoga Drive address. She can go back to that address on one occasion with law enforcement to retrieve any belongings that she might have there. No drugs, alcohol, or weapons while out on bond. Good luck to you, Ms. Leftwich.
Thank you, Your Honor.
Thank you, Your Honor.
What's the spelling of the last name, Ms. Bacchus, of Sylvia? Is it Reed, R-E-E-D?
R-E-I-D, I believe.
Okay, R-E-I-D. All right, thank you. Who do we have next?
That's it, Your Honor. For position 10, Ms. Street is a medical reset.
Okay, it's medical reset until 9/13. And what about position number 25, Stephanie Street?
That was Stephanie Street with a medical reset. I got the position number wrong, Your Honor. I apologize.
Okay, well, what about position 10, Ashton Green?
A waiver was filed by PD Kim on that case, I believe, Your Honor.
Okay, so for Ms. Street, 25, that's 9/13 reset. And so we have a waiver of appearance on Ashton Green.
Yes, Your Honor.
Okay, let's see. Is there a history for Mr. Green?
Your Honor, excuse me, before you continue, Ms. Courtroom 3B, dismissed, sir.
Okay, yes, we'll see you tomorrow.
All right.
Okay, bye-bye. I'm trying to get everybody dismissed. I'm sorry, I'm moving too quickly. Let's see. Is there a history for Mr. Green?
Is this Ashton Green, Your Honor?
Yes, position 10.
The defendant has 21 cycles. The defendant's last arrest was January the 22nd, 2022 for possession of methamphetamine. There was no disposition for that arrest. The defendant does appear to have an open case pending in Fulton County for simple assault. That case number is 20 CR 00385-7 in the letter E. The defendant does have prior arrests, one in 2019 for simple battery, one in 2009 for simple battery. The defendant does have a prior felony conviction. It's in 2011 out of Clayton County for possession of marijuana with the intent to distribute. The defendant does have misdemeanor convictions and sentences. It's one in 2021 for theft by shoplifting. And the defendant received a nolo contendere sentence in 2017 for battery, family violence. And there was one in 2012 for driving while license suspended or revoked. And the defendant received a nolo contendere sentence in 2012 for driving while license suspended or revoked. And there was one in 2011 for simple battery, family violence, and disorderly conduct. And there was one in 2007 for possession of marijuana less than an ounce. Nothing in addition, Your Honor.
Thank you. Ms. Tortorella?
Yes, Your Honor. For the simple battery, we're asking for a $4,000 surety bond. The conditions is no contact with the victim. His name is Horace Simmons. The first name is Horace. The last name is Simmons, traditional spelling. To stay away from 1400 Lee Street in Atlanta. 1 day anger management, no drugs or alcohol, no weapons, and no new violations of Georgia law. Your Honor, this incident occurred on 9/11/2022 at the incident location stated on record. This defendant poses a threat and danger to the person of Horace Simmons. The defendant, Ashton Green, intentionally made physical contact of an insulting and provoking nature with Mr. Horace Simmons by punching him in the mouth. The defendant was arrested and all these events occurred in Fulton County, Georgia. To add, Your Honor, he's a flight risk and he poses a risk of reoffending while out on bond and a risk to public safety. He has an open case, as you heard, for pretrial 20 CR 003-847E, where he's charged with simple assault, family violence. It's an open case. It's an ORCA case. This incident occurred on June 29th, 2020. Your Honor, he also has 21 cycles. He's been arrested for violent offenses in the past, a simple battery in 2019, simple battery again in 2009. A recent arrest this year, January 22nd, 2022, of felony possession of meth. And the list goes on and on and on. Your Honor, he has a previous family violence case, but now he is committing violent actions against people that are not related to him. So for that reason, Your Honor, we are concerned for public safety, and we do feel the $4,000 surety bond is more than reasonable with the stay away. Nothing further.
Ms. Kim?
Yes, Your Honor. Mr. Green is 35 years old. He resided here in Georgia for 15 years. And actually, he's not actually attacking strangers. They have a relationship, but they do not reside together, and they do not have any children together. So we would like to, and then also he has a family members here in Georgia, and actually his new job at Family Dollar store, retail store, starts tomorrow at 8 a.m. It will be first day. So he's very nervous about that because he does not want to lose his job. He graduated from high school, and we would like to request for $4,000 signature on bond, Your Honor. Thank you.
All right, it's going to be a $3,000 good bond, no further contact with Mr. Simmons, stay away from the Lee Street address, no drugs, alcohol, or weapons while out on bond.
Thank you, Your Honor.
All right, and I think that concludes the 2 o'clock calendar. I have Ms. Grace here with me. Ms. Jackson, I do believe that I need one waiver. Is that right?
Yes, are you in the
Yes,
courtroom?
I'm in G33, yes, so.
Okay, I'll bring it over. I didn't get that, the adult cosigner name. Are you just wanting to leave it blank or what?
For which case?
That was for Shakara Jones.
And what, do you know what position that is?
No, I'll find it.
Okay.
I believe it's 17, and I placed that in the chat. Deborah Carr, DEBORAH. I sent a direct message to Ms. Jackson.
Thank you.
Okay, yes, and I do have down that it is Deborah Carr.
Okay.
Okay, so when Ms. Grace is ready, we'll go over the calendar.
Position number 1 is $1,000 good bond. Position number 2 is a $3,000 sign on bond to the jail. Position number 3 is a $1,500 good bond. Position number 4 is a $3,000 good bond. Position number 5 is a $2,000 pretrial bond. Position number 10 is a $10,000 good bond. Position number
You went from 5 to 5 to 10. Okay.
$10,000 good bond. Position number 7 is a $2,000 good bond. Position number 8 is a $1,000 good bond. Position number 9 is a $3,000 SOB through the jail. Position number 10 is a $3,000 good bond. Position number 11 is a $1,500 good bond. Position number 12 was an all prize. Position number 13 is a $1,000 good bond. Position number 14 is a $2,000 pretrial bond. Position 15 is a $5,000 sign-on bond to the jail. Position 16 is a $1,000 good bond. Position 17 is a $3,000 good bond. Position 18 is a $1,000 good bond. Position 19 is a $1,000 good bond. Position 20 is a $2,000 sign-on bond through the jail. Position number 21 is a $2,000 sign-on bond through the jail. Position
I've
22.
got through pretrial in that 21.
I have to pretrial as well.
Position number 22, 3,000 pretrial. Position 23, $3,000 pretrial. Position 24 is a $4,000 good bond. Position 25 is reset for tomorrow's SEA calendar. Position 26 is a $5,000 pretrial. Position 27 is a $3,000 pretrial. Any concerns or questions?
Okay. All right, so I'll see everybody tomorrow. Have a good evening. And Ms. Jackson, I'll be here till you, so I can sign that this afternoon, okay?
Yes, Judge.
All right, y'all have a good evening. Thank you.
You too, Your Honor. Thank you.